Pertaining to control bank for delivery of judgment. Item 1. Criminal appeals with 2025.
Jail appeal dismissed.
Item 2. ASL 54 of 2025 in Beta 6 of 2025.
IA dismissed with cost of rupees 25,000.
Item
Deeply
number
obliged.
3 and 4. ISL 116 of 2025 and ISL 117 of 2025.
Both the IAs were IAs are disposed of by this common order, dismissed.
Obliged.
May I please, Your Lordship?
Yes.
Item number 42 and 43 may be withdrawn, madam.
42 and 43.
Yes, madam.
Heard, Mr.
Jet Hussain.
Learned counsel for the petitioner. The learned counsel for the petitioner submits that he has the instruction to withdraw these two petitions. Fair allowed. This IA criminal number so and so since the disposal on withdrawal. Liberty not required.
Not required. Much obliged, my lord.
Item for motion be item 1.
May it please your lordship. Lordship, in this matter, it is charge sheeted, lordship, and trial has commenced, lord.
Sarcited.
Yes, lordship. Trial has commenced, lordship. NDPS commercial quantity, lord. TCR may be called for, lord.
This year. Okay. This year from which court?
District and Session Judge Udalguri, lordship. Special Judge NDPS.
Special Judge NDPS Udalguri fixing the matter on
24.
24th.
Obliged.
Item 2.
May it please, Your Lordship. So the 43 bail application, Lordship. Allegation is under section, Lordship, 3, 4, 5, and 7 of the Immoral Traffic Prevention Act, Lordship. Lordship, in this case, Lordship, search and raid was not conducted by the Lordship special police officer, Lordship.
Where it is provided
Lordship,
that search and seizure is to be made by the
Lordship,
special police.
page number 17, Lordship. Seizing officer, SIP Deposit Vaishnav, Lordship. Page number 17, Lordship.
No, where it is provided that it has to be done by the special police officer.
Lordship, section 13 of the Lordship code Act, Lordship,
Okay.
Immoral Traffic Prevention Act, Lordship.
Section.
Section 13 Lordship. Official police officer and advisory body Lordship.
Board member. Section 13 of the immoral traffic. No, you see, a seizure was made by SI of police. But here it is provided that not below the rank of inspector of police. Okay, you obtain instruction, we will take it up at 2 o'clock.
Always Lordship.
Item 3.
Next, please, your Lordship. FIR is at page 16 and 17, Lordship. 5.2 kg ganja was allegedly recovered, Lordship. Suspected ganja was recovered. I am behind the bar for last 49 days, Lordship.
Last
49. Recovery was made on 23/6, and I was in jail since 20. We are in jail for 24/6, Lordship.
20.
24/6. So 5.2 kg ganja was recovered. Suspected ganja was recovered, Lordship. And our ground is, apart from the period of detention, non-compliance of section 36, Lordship. Arrest memo do not bear any signature of any witness, Lordship. Arrest memos are at page 33 and 34, 35, Lordship. Period of detention also may kindly be considered, Lordship. 49 days already, Lordship, behind the bar, Lordship. It is a 60 days offense, Lordship. And seizure has been made, so only for FSL may be pending.
Yes, board accord. For. Is it necessary to peruse the case diary here? Because he is already behind the bar for 49 days.
49 days, Lordship.
Hard may support the learned counsel for the petitioner. Learned counsel for the accused and Mr. Bartakur learned additional PP for the state respondent. This application under section 480 of the BNS 2023 is prepared by accused. How many accused are there?
2, Lordship. Suren
Accused of
Talukdar and
Surendra
Nabo Talukdar.
Talukdar and Nabo Talukdar who are languishing in Jailazut since 23rd 6 2024. No, since 24/6/2024. In connection with Bagbor PS case number 54 of 2026 under section 20, we can make it B, we can make it Roman 2, we can make it no, capital B stroke 29 NDPS Act. It is to be noted here that above noted case has been registered on the basis of one FIR lost by one. Moina Das, WSI of police. Mandia Police Outpost, Barpeta, on 23rd 6 2026. The allegation against the present petitioners are that present accused are that they are found in possession of 5.210 kg of ganja on 23rd 6 2026 at about 7 p.m. while they were carrying the same from Al Hazi's side towards Agmandia village for the purpose of illegal sale and distribution. Mr. Putter, learned counsel for the accused, submits that the accused were arrested on apprehended on 23rd/6/2026 and remanded to Jail Hazard on 24/6/2026, and since then they are languishing in Jail Hazard for 49 days. Mr. Putter further submits that while causing arrest of the accused persons, the IO has not complied with section 36 of the NDPS or the BNSS,
BNSS 36.
BNSS 2023. And that in the interest of investigation, further custodial detention may not be required, and therefore he is contended to allow the application. On the other hand, Mr. Portakur, learned additional PP, has opposed the petition, and he submits that CD may be called for fixing a short date. Having heard the submission of learned counsel for both the parties, this court has carefully gone to the petition and the documents placed on record. And it appears that both the accused were apprehended on 23rd/6/2026 and they are languishing in jail as of since 24/6/2026 for last 49 days. Further, it appears that the quantity of contraband substance allegedly recovered from the possession of the accused are of 5.210 kg, which are of intermediate quantity, and the statutory period of detention for the aforesaid offense is 60 days. Thus, considering the nature and gravity of the offense and also the period of detention, further custodial detention of the accused person seems to be not warranted here in this case, and accordingly this court is inclined to allow this petition. It is provided that on furnishing a bond of rupees 20,000 each with one surety of like amount to the satisfaction of the learned special judge NDPS Borpeta, the accused persons be enlarged on bail.
Item 44,
Deeply obliged, Lordship.
item 44.
None appears for the petitioner on call. The applicant on call is the matter after 1 week. In the event of subsequent non-representation, appropriate order shall follow.
Item 45.
May I please, your lordship? My lord, tax, lord, matter. Lord, basically, we are apprehending arrest in connection with a proceeding which has been initiated by the state GST, my lord. As someone had been issued, my lord may be pleased to find, it is at page 20, my lord.
Here is.
Oh, big over.
We have served copies also, my lord, to them.
Okay, you inform after some time.
My lord.
Item number 4. Item 4.
Thanks, your lordship.
Yes.
We have approached earlier this honorable court by way of anticipatory bail application in this case, your lordship. But we have to withdraw it since there is a strict bar under the act that no anticipatory bail will lie. So as an alternative measure, we have filed this application under Article 226, taking read, your lordship. The facts of the case is that FIR was lost, which your lordship will find at page 20.
Date of Assam. You served a notice upon the government advocate
Lordship, I'll ask
after some time.
after some time.
Item number 5.
Okay.
Item 6 and 7.
Item number 6 and 7, my lord. Earlier, case ID was called for, but I have received one report from you When I was in both these cases, my lord, charge submitted. My lord. There are two cases, Tamilpur case number 102 and number 6, and item number 7, Tamilpur case number 0136. In both cases, my lord, charge submitted.
So what is the pair in this petition?
May I please, your lordship? Your lordship, there was a dispute between the husband and the wife. So there are two separate FIRs, one lodged by the husband and one by the wife. After going through everything, the family was involved, and then they decided not to listen to the family. And when they started, they reconciled again. When they talked, they reconciled again. Now they are together, and they both have filed for quashing. That is two different cases, like item 6 and 7, and it is a joint petition, your lordship. So both the parties have settled the differences between them, and that's why we are before this honorable court, in order to quash that, so that they can live in peace, your lordship. They have settled every matter between them. Now this FIR, the now charge sheet has been
That's all
submitted.
right. Whether the copy of charge sheet is available with you?
No, we have received the information now, your lordship, from
Okay.
the learned public prosecutor, sir. We have received
Okay,
that.
then we will call for the scan copy of the record.
Yes, my lord.
On next date, we will consider it.
Actually, already there, my lord. In chain protection, no coercive action, my lord, that is already there, my lord, in the reference.
Already there.
Yes.
Heard, Mr. Your name, please?
As Bhuya, your lordship.
As Bhuya, learned counsel for the petitioner. In both the petition,
Yes, my lord.
One is A Sharma, he's there.
and Mr. A. Sharma in criminal petition number 952 of 2026. Mr. Borthakur learned additional PP for the state respondent. Mr. Borthakur apprised this court that though CD was called for, yet the same has not been received, and as per his inspection, the IO has completed investigation and submitted charge sheet before the learned trial court. In that view of the matter, it is provided that recessal call for the scanned copy of the record of Tamilpur PS case number 101 of 2026 and Tamilpur PS case number 102 of 2026 from the court of learned, where it is filed, Borthakur?
Tamilpur. My lord.
Additional Chief Judicial Magistrate Baksa, fixing the matter on 26 August.
Number 8.
Obliged, your honor.
Lordship, the senior counsel is out of station.
Pardon?
The senior counsel is out of station. So the matter please be set on another day.
Okay, Miss, your name, please? Your name,
R. Sharma.
R. Sharma,
Yes,
learned counsel appearing on behalf of?
R. Sharma.
No, your name,
J.M. Sharma.
learned counsel appearing on behalf of Mr. R. Sharma, learned conducting counsel for the petitioner. Press for listing the matter
Friday, Your Honor.
after
After some time, Your Honor. I mean Friday. On
next Friday.
Yes.
Next Friday, madam.
Next. On 25th August. Item 9.
I have to provide the written, but he has only served the 45 days with only through WhatsApp.
WhatsApp,
Only through WhatsApp.
but WhatsApp is not permissible. That is not permissible. Okay, we close the notice.
There's no case also yet.
We allow the petition.
Item
Hello.
10.
May I please, your lordship? My lord, proceeding under section, my lord, 138 of the NI Act is pending against me, my lord, and my lord, a warrant of arrest has been issued against me, my lord, by it order dated, my lord, 18/7/2026, page
Page number?
25. Page 25, my lord.
25.
Otherwise also, my lord, a case has already been settled between the parties, my lord. But page 25. And next date is, my lord, 10/9, my lord. So till then, my lord, it may be stayed, my lord. On the next date, my lord, I will appear, my lord. And page 24, my lord, settlement. It has been reflected by the order, my lord.
Why you could not appear before the
Because, my
court on
lord,
that day?
Because, my lord, on that day, my lord, some difficulties were there, my lord.
What
My-
difficulties?
My lord, Actually, my lord, my mother's illness, my lord, because
Where is the medical document?
I have not annexed, but my lord, my engaged counsel was instructed to file the petition. My lord, he has not filed, my lord. That is the problem. Kindly turn to page 24, my lord. It has already been settled also, my lord. My lord, 70K, my lord, only 70,000, my lord. Out of 5 lakhs, it has been settled for 70,000, my lord, page 24. So on the next date, I will appear and I will make payment, my lord. Date 10/9, my lord. Next date 10/9, my lord.
Pardon me, sir.
S.H. Sikdar.
Learned counsel for the petitioner and Mr. Bhattakar, learned additional people for the state respondent. Okay. In this petition under section 528 of the BNSS 2023, the petitioner has tried for causing the order dated 18/7/2026 and subsequent order dated 38/7/2026 passed by the learned subdivisional judicial magistrate S. Kukrazar in CR within bracket NI case number 28 of 2025. It is to be noted here that by the impugn orders dated so and so, the learned trial court has issued non-bailable warrant of arrest against the petitioner for default. Mr. Sikdar, learned counsel for the petitioner, submits that on 18/7/2026, the petitioner could not appear before the court. Then he instructed his lawyer to file one application on account of the illness of his mother. Then he instructed his lawyer to file an application before the learned trial court, but his lawyer did not file the application, for which the learned trial court has issued non-bailable warrant of arrest against the petitioner, and also by order dated 38/7/2026, the learned trial court has again directed to issue non-bailable warrant of arrest against the present petitioner. Referring to the order dated 11/3/2026 at Annexure 5
My lord.
of the petition, Mr. Sikdar submits that the matter has already been settled between the parties in mediation. And on next date, the petitioner will make payment of the amount before the learned trial court and will will appear before the learned trial court on next date and will settle the dispute. Will settle the case with the respondent hearing. And therefore, he has contended to interfere with the impugn orders dated 18/7/2026 and 38/7/2026. Having heard the submission of learned counsel for the petitioner, this court has carefully gone through the petition and the documents placed on a record, and also for the impugn order dated 18/7/2026 and 38/7/2026. And also the also the order dated 11/3/2026. It appears from the order dated 11/3/2026 that the parties have settled the dispute with terms and condition at rupees 70,000. 70,000 payable by the petitioner hearing to the complainant within a period of 30 days. And in that view of the matter, and also in view of the submission of Mr. Sikdar, in view of the assurance given by Mr. Sikdar that on next date, which is fixed on 10/9/2026,
My lord.
the petitioner will settle the dispute with the respondent by paying the amount of rupees 70,000. This court is inclined to allow this petition. Allow this petition. till 10/9/2026, the non-bailable warrant of arrest issued against the petitioner by the impugn order dated 18/7/2026 and 30/7/2026 shall be kept in abeyance. If you fail to settle, then non-bailable warrant
my lord,
will be
my-
issued again.
My lord, plus my lord, item 11 also, my lord, same, my lord, part payment of rupees 30,000 has already been made, my lord. Page 24, my lord. Petitioner is same, my lord. Page 24, my lord, kindly.
How many cases are pending
My
again?
lord, three cases, my lord. Three cases, all, my lord, all have been settled, my lord. My lord, here, my lord, already 30,000 has already been paid, my lord. Page 24. Same, my lord, date 10/9 is fixed, my lord. My lord, same prayer, my lord.
Order dated 12/2/2026, Annexer 3 instead of Annexer 5, same order.
Sorry, my lord, item 15 also same, my lord. 15, 1/5. Here also, my lord, settled. And non-bailable warrant of arrest was issued on 37/2026. Page 23.
Impugn order dated 30/7/2026, and the compromise order is at 11/3/2026. Annexer 5, and the amount is 80,000.
Hello, bless.
May it please your lordship. This is a quashing of NIX proceeding, lordship. Already, lordship, yesterday I mentioned another matter to be listed along with this matter, lordship, that your lordship allowed me to be listed on 12, lordship. Tomorrow that will be listed. There were 5 doctors, lordship. They are the partners of, and they opened a hospital, lordship. And thereafter, to run that hospital, lordship, they have taken the assistance of this respondent, lordship, the complainant. The annexure 1, your lordship will find the,
You have put the respondent number 1.
Lordship, we have just read our Vakatnama today, Lordship, we do not have the.
but in this case, notice was not yet issued, lordship.
We
Today is the
have
motion.
That we have accordingly come to the court, Lordship. Lordship, we just maybe give it copy and short date may be fixed, Lordship, if in that. time.
Already, lordship, another matter was earlier listed, and in that case, lordship, stay was granted by a coordinate bench of this court, lordship.
Lordship, but there are disputed, with respect to this, there are disputed questions of fact here. So some opportunity.
To the order will-
of hearing as well.
Lordship may kindly go through this criminal.
Okay,
petition.
today we will issue notice. Let him file objection if
Lordship.
he wants.
Stay will be required in this matter, lordship. The next trial court proceeding is going on, lordship.
When?
Earlier, lordship, already is in a similar.
When the next date is fixed.
In the tomorrow's matter is fixed on 14/8, lordship. and
Today's matter.
Today's matter, lordship, I have to check, lordship. It will next date.
Okay, after 1 week. Or is Arsoduri learned senior counsel assisted by Ms. So-and-so, learned counsel for the petition.
Lordship may fix tomorrow that both the
Mr.
matters may be taken together, lordship.
Hey, Mishra.
A. Mishra, learned counsel for the respondent number 1, Mr. Portagur for the respondent number 2. In this petition under section 528 of the BNSS 2023, the petitioner has challenged the prayed for quashing NI case number 249 of 2025 pending before the Court of Learned Judicial Magistrate First Class, Dibrugarh.
Next, Lord Kotori to Mali.
Where is the petition and the documents placed on record? Let notice be issued to the respondent returnable on. You inform this court about the date
Lordship.
returnable on. However, no formal notice is required to be issued since Mr. Mishra and Mr. Bortakur entered appearance and received notice. However, extra requisite copy of the petition be furnished to them during the course of the day. list the matter on for consideration of interim pair. In the meantime, the respondent number 1 may file his objection if so advised.
Lordship, I am furnishing.
Inform the court.
Wait, please, your lordship. In this case, your lordship, a warrant of arrest has been issued against me, your lordship. I'm only praying the. At page 18, your lordship.
Where is the impugn order?
Page 18, your lordship. NBWA issue against me, your lordship.
Why you could not appear?
I instructed my counsel, your lordship, he didn't take any step. That was what was told to me, your lordship. That is why no steps were taken and a non-variable warrant of arrest was issued, your lordship.
No,
I was sick also, your lordship.
Pardon?
I was sick also, your lordship. I instructed my counsel, your lordship, but the counsel didn't appear, your lordship. No representation was filed on my behalf, your lordship.
When the next date is fixed?
Next date, your lordship, he said. Uh, 19/5. Within 1 week, I will appear, your lordship, if your lordship. Within
You
1
do not know the next date also. Heard Mr. T. Deori, learned counsel for the petitioner, Mr. Borthakur, learned additional counsel for the state respondent number 1. This petition under section 528 of the BNSS 2020, the petitioner has challenged the order dated 2/4/2026. It is to be noted here that by the impugn order dated 2/4/2026, the learned Chief Judicial Magistrate Bozali Patchala has issued bailable warrant of arrest against the petitioner. No, non-bailable warrant of arrest against the petitioner. Yes, the bailable warrant of arrest issued against him returned after execution. Mr. Deori, learned counsel for the accused petitioner, submits that the petitioner is accused in NI case number 47 of 2023 pending before the Court of Learned Chief Judicial Magistrate Bozali Patchala. In the said case, bailable warrant of arrest of rupees 3,000 was issued against the present petitioner, and the same was executed. But and the next date was fixed on 4/6/2020. No, 2/4/2026. But the petitioner could not appear before the learned trial court on account of illness. He has instructed his lawyer to file an application. But his lawyer did not file any application for which the learned trial court has issued non-bailable warrant of arrest against the present petitioner. What was the ailment he was suffering from on that day?
I'm suffering from, your lordship, arthritis and diabetes, kidney
Mhm.
problems. I went the certificate, your lordship.
Your certificate is of dated 2/7/2026. And the warrant of arrest was issued on 2/4/2026.
On that day, I was suffering from some ailment, your lordship. That was what my instruction was.
Though Mr. Deori submits that the petitioner herein was suffering from diabetes, hypertension, chronic kidney disease, and he has enclosed one medical certificate, medical prescription as annexure 3 of the petition, in the petition. Yet the same pertains to the date of 2/7/2026, while non-bailable warrant of arrest was issued against the petitioner by order dated 2/4/2026. So, Bortakor?
Yes.
Anything to submit by you?
Yes, sorry, QPR from the party.
Para, having heard the submission of learned counsel for both the parties and also considering the facts and circumstances on the record, this court is inclined to dispose of this petition by directing the petitioner herein to appear before the learned trial court within a period of 1 week from today and to apply for regular bail. And in the event of filing such an application, the learned trial court shall consider the same in accordance with law. Till appearance of the petitioner before the learned trial court on 18, the non-bailable warrant of arrest issued against the petitioner shall be kept in abeyance.
I'm very grateful, Your Lordship.
Standing item 45.
May I please, Your Lordship? My Lord, this is basically a pre-arrest, my Lord, apprehending arrest, my Lord. A bail petition had been preferred.
No,
My Lord, a proceeding had been initiated.
Bortakor,
Yes, someone has been issued by the central GS.
My Lord,
Someone has been issued by the central GS.
GS.
So state has been a party. So they have clubbed together all the issues because his registration are also put under cancellation. Now someone has been issued under section 17. Against that, he has approached the court seeking various bail.
may
What may kindly please to see section 17.
seventy.
Someone has been issued.
no, here state is the party. Bortakor, who will appear here?
B. Gogoi generally appears.
You inform him.
Lord, basically, he is a formal party, my Lord. We are not
Formal
challenging
party.
any so cause or, my Lord, any, my Lord, the cancellation of the GST. We are only, my Lord, appearing, my Lord, the prayer before my Lordship is that responding to the summon, my Lord, we will appear and cooperate with the investigation, my Lord, whatever the document and, my Lord, what amount of tax, my Lord, I have evaded, that has also not been disclosed in the summon also, my Lord. Now, my Lord, kindly see at page 20, my Lord, annexure 2. Under section 70 of the Central Goods and Service Tax Act 2017 to Mr. Pankaj Kumar Das, whereas I, Punna Kumar Deka, am making inquiry in connection with investigation against MS Pankaj Kumar Das under the Central Goods and Service Tax Act 2017, and whereas I consider your attendance necessary to give evidence and oblique or produce the documents or things of the following description in your possession or under your control, to subscribe the statement, to tender the documents and other. Now, therefore, in exercise of the power vested me under section 70 of the Central Goods and Service Tax Act 2017, I do hereby summon you to appear before me in person or by an authorized representative to so-and-so at 11 a.m. at the office of the room number so-and-so, so-and-so. Inquiry as aforesaid is deemed to be a judicial proceeding within the meaning of section 229 and 387. So, my Lord, this summon is very clear, my Lord. I need to go and appear and to, my Lord, present myself. Now, my Lord, the issues are as such. There is a provision of, my Lord, under section 69 of the Central Goods and Service Tax Act, that is the power of arrest. Now, my Lord, such in this type of situation, my Lord, my Lordship knows, my Lord, when this type of people goes there and presented themselves, they immediately take him under custody, my Lord. Such type of incidents are happening in the state, my Lord, and even, my Lord, the what amount of tax, my lord, I have evaded, what offense I have committed, nothing has been disclosed in this summons. So, my lord, I am ready to present myself to the investigating authority, my lord. Only thing is that, my lord, I need some protection, my lord, from my lordships, my lord. Because, my lord, as per my, my lord, statement, what I have received the instruction, my lord, that there is nothing as such. If I go there, my lord, if some tax has been evaded, my lord, if some penalty or some, my lord, required to pay, I am ready to pay. But only thing, my lord, is that in such type of cases, arrests are being, large scale arrests are being carried out, my lord. Lots of bail petitions are coming. My lord, one of the petition, my lord, I have also annexed before my lordships in this petition is at page 25, annexure 6, my lord. So, my lord, this is at page 26, my lord, exactly a similar summon, my lord, had been issued. And a case has also been shown in this, my lord. And thereafter, this honorable court, my lord, was pleased to grant the interim, my lord, by an order dated 6/11/25. And after my appearance, my lord, the investigation completed. And a final, my lord, offense report has also been submitted. And thereafter, my lord, this petition was closed by a final order, making the interim absolute, my lord. Now, here is also, my lord, I am apprehending arrest in as the summon had already been issued, my lord. My lord, even I am ready to present myself, my lord, in before the investigating officer, my lord. That is my only limited prayer and the protection, my lord, because, my lord, I have not committed any such offense, my lord. I am not an hardcore criminal also, my lord. Their allegation is that I have evaded. Now, my lord, may kindly I beg to draw my lordship's kind attention to another important document. The Panchnama which has been, my lord, prepared before the summons, my lord, may kindly turn to page 17, annexure 1, my lord.
Yes.
Panchnama dated so and so, my lord. These are the Panch 1, Panch 2, my lord. I think, though, my lord, I am very, my lord, poor in the tax knowledge as my lord. This Panch may be the witnesses, my lord, in whose presence this has been carried out. On being called upon by a person who introduced himself as Sri Govind Singh, Inspector Headquarters, Anti-Evasion Unit, CGST, Gauhati Commissionerate, GST Bhavan, Machkhua, Gauhati 1, we, the above named Panchas, presented ourselves at the office premises of so and so, located at Sarpara Mirza, Harpara, Kamrup, Assam, 7 so and so at around 13-14 hours on so and so. The said officer then informed us that they have a reasonable belief that MS Pankaj Kumar Das so and so, located at so and so, Kamrup, Assam, is indulging activities in contravention of the provision of the Central Goods and Service Tax so and so Act 2017 and rules made thereunder to evade tax, and under the said act. They further informed us that as per their office records, the said company is a registered taxpayer with the GST department holding a GST registration number so and so, and today they intended to inspect the office premises in connection with their case of evasion of GST by so and so, so and so. The officer requested us to remain witness to the inspection proceeding, to which we agreed voluntarily. The said officer then introduced us to his other colleagues accompanying him, namely Sri Punya Kumar Deka, Superintendent, Sri Sumit Kumar and Mr. So and so, both inspector from headquarters, Anti-Evasion Unit, Office of the Commissioner, GST, CGST, Gauhati, by showing their departmental ID cards. The officer then showed the authorization for inspection of the premises of
Mr.
my lord.
Yeah, okay, all right.
So therefore, my lord, as I am not able to present themselves, my lord, therefore these all discrepancies are going on. Even my GST has also been, my lord, suspended. So therefore, my lord, I am ready to cooperate with the investigation. I will go and appear. My lord, some protection may kindly be provided, my lord.
Yes.
Lordship, here only summon has been issued, but still has seen section 7.
Mm.
And Lordship, Most Honorable Court in many cases has find that before arresting section 35, 3 notices mandatory. That is, that has not been issued. Here, Lordship, only inquiry is going on. There is no apprehension at all. And before making arrest, Lordship, we have to undergo a number of formalities. Like Lordship, we have to issue notice under section 35(3). That's section 69, commissioner's approval is necessary. That is everything is absent in this case. There is no apprehension at all. The Lordship, my learned friend has annexed some document by which he said the case deposited as Page 23, Annex 5.
Page number?
Page 23, my lord. Yes.
Yes.
This payment has been made
That
on
he has made payment of rupees 5 lakh. To the operative on 27,
28/7.
28/7/2026, when the search was made to his office. The lordship section 32. The offense is provided. Lordship. 132. The punishment is provided, then there is a addition of tax about 5 crore,
Right through.
then it is non-bailable. Below that, it is bailable offense. And after for that, lordship, we have to undergo many punishments.
Section?
132.
132, my lord. Punishment for certain offences.
It says lordship section 1. And it then goes on and retain the. Lordship, next, shall be punishable. Lordship, go. If there is a, lordship, the punishment is established as amount of the tax addition. If it is 5 crore or more, then it is said to be the non-bailable offense.
What is the amount?
My lord, no, it has not been disclosed, my lord.
That when the lordship inquiry.
So according to you, there is no apprehension of arrest.
Yes,
My
lord.
lord.
Only
Yes,
someone
lordship.
was issued to him.
Lordship, before making arrest, lordship 35 notice is mandatory. That part provided by dishonorable hotel management.
Hmm.
That has not been issued. The lordship 69 approval is not there. Only a notice, someone has been issued under section 17.
Hmm.
Lordship, that is clear. He has to appear before the authority. Lordship.
Hmm.
There is no apprehension at all.
Okay.
My lord, I am not, my lord, doubting my learned, respected senior friend submission, my lord. What in this type of cases are doing, everything they keep ready, my lord. 35, the notice and approval, we do not know, my lord, what's going on behind our back. Now, my lord, when I present myself, my lord, they will certainly, my lord, I am also sure that this person is also going to be arrested, my lord. Even, my lord, the officers, my lord, are sitting in the office from last 4 days, my lord. One staff goes and other office for 24 hours vigilances are going on, my lord. So once I go, my lord, such a fear psychosis had been created. My wife has also been interrogated, my lord. Kindly appreciate the
Okay.
situation, my lord.
Mr. Gogoi, anything to submit?
Regarding the apprehension, as stated by the legislative council. Well, 35 notice is given, even when 5 cases are listed, put it on open foot, where they are behind the parts. They are also 35 notice was issued, despite that, when they did not appear,
Then
they
some.
were arrested. And here, this is a summary, notice under section 70, it is a summon.
Hmm.
And if you lordship kindly see the provision section 70 of the GST Act,
Hmm.
it is an inquiry matter.
Hmm.
Subsection 2.
Hmm.
Nearly every such inquiry refers to in subsection 1 shall be deemed to be a specific within the meaning of section 20 of the Indian Penal Code. But if that be shown, section 35 is mandatory, even the Honorable Supreme Court has held, but in GST matters, 35 notice will have to be there.
Hmm.
Earlier, the 41 is notice. When that notice is issued, probably he can apprehend that I may be arrested.
My lord, well.
And Lordship will see another document. It's regarding a notice for cancellation of registration. How can that be a ground for pre-arrest bail?
No, my lord, we are just producing it, annexing it, this situation. We are not, my lord, just bringing on record this
Moment
cancellation, my lord.
passed today,
My lord, this section,
proceeding every inquiry, from the part of the GST or the state GST, all will be full.
No.
And
My lord, that-
apprehension is premature as only.
my lord, my,
Always come, without 35 notice, we cannot,
my lord,
It is clarified,
Already lordship in many.
That's the law.
Unknown
That's the
notice
law.
is stated.
no, my lord, my respected friend submissions, my lord, I am very sure, my lord, that without 35(3), if they make an arrest, my lord, it will be unconstitutional, my lord. That is, the law is well settled. But my lord, when I go there, how, my lord, immediately they will produce the 35(3). It is a piece of, my lord, it is a document, my lord. They can prepare on the sitting itself, my lord.
notice
That is the situation, my lord.
Time and date is fixed. When you have to appear before also, it's not in his office.
My lord,
35 and
my lord, many things are there, my lord, which I cannot disclose, my lord. That's the problem. That is not on record, my lord. My lord, what I am asking, my lord, that I will cooperate with the investigation, my lord, that only then no coercive action may be taken, my lord. That observation, my lord, may be pleased to
But
give,
then
my lord.
you will seek a, my lord, order in
My
the
lord.
petition. How, my lord, in a bail?
No, my lord, in such type of situation, my lord, can be given, my lord.
You can challenge it, my lord. There are cases pending, my lord.
Because, my lord, I am sure that this person is also going to be arrested, my lord, once he presented himself. my
No,
lord.
no,
That is the
Mr.
My lord,
Bhuya, you
My lord.
say the condition precedent is that you must have apprehension of arrest.
My lord.
If according to their submission, there is no apprehension of arrest, this petition is not maintainable.
No, my lord, according to them, my lord, it is not, apprehension is not there, my lord. But
Mm.
according to me, as the proceeding has been initiated, my lord,
Mm.
the inquiry
No,
is going on.
proceeding has been initiated,
Initiated,
they have
yeah.
issued notice to you, you
My
go
lord,
and
someone has
attend
been
there,
issued. Someone has been issued
you
to
go
appear,
and
my lord.
appear before the authority.
No, my lord, that's why, my lord, I am before my lordships, my lord, I will go and appear, my lord, but I should not be, my lord, put behind the bar, my lord. Without following the due procedure of law, my lord.
No, they have already submitted that there is no apprehension of arrest.
No, that
Then-
submission, if, my lord, I have a full faith on my respected senior friend submission, my lord,
Then-
that submission can also be recorded by my lordships, my lord.
Mm. Okay, we will record their submission
My lord.
and we dismiss this petition.
My lord, my lord, my lord.
You will only say, my lord, by following the procedure. 35 and notice will be 35, 3 notice will be issued, my lord. And time and date, my lord, that will be placed, my lord. And where to appear, that will be also.
No, that's
mentioned.
all right, okay.
Obliged, deeply obliged.
May I please, your lordship? Lordship, previous item may be taken, my lord. Item number 44, I missed it, my lord. After making mention, my lord,
They
this
have
matter,
taken that.
my lord, after making mention, this matter was listed, my lord.
Maybe
Is it
we
urgently
have
is
called the
hereby-
matter, but no one entered appearance. Yes.
After item 53 for orders.
My lord, may kindly come to page number 8.
Whether notice was served upon the other side,
Yes, my lord, yesterday I will send.
who appear, upon whom you serve,
CBI,
correct. CPI council.
because I am told that the council, my lord, the council is out of station. So we have served it in the CBI office. There was a person and I have personally been there, my lord, because
Okay. Wait for some time. Have you put it here? Inform को it.
Item 32 for order.
I'm appealing for respondent number 23, lordship.
এসপ্তাহ পিছত দি দিয়ক।
I am appearing for respondent number 23, lordship. I have instructed from the both sides, lordship. Petitioner as well as the respondent number also. The petitioner is instructed to us, they will go through the matter, lordship. But my learned friend is,
Who is appearing?
T.A. Lashkar and, Agarwal.
Okay, you inform him then. After some time.
Then after, Monday or Tuesday, lordship.
Okay. None appears for the petitioner on call. However, Mr.
Alim Sheikh, lordship.
A. Alim Sheikh, learned counsel for the respondent number 2 and 3.
Yes.
And Mr. Bortakur for 1. Present. List the matter on Monday,
Tuesday, lordship.
Tuesday. In the event of subsequent non-representation of the petitioner, appropriate orders will follow.
On 33.
May I please your lordship? So this is an IA application for condoning a delay of 198 days in an NI case, lordship. So family, I issued the check, lordship, so 198 days delay is there. There were talks going on between the parties, but ultimately it did not give any fruitful result. Notice
Whether
was
notice
served,
was served
number
or
two,
not.
Wakalatnama has been filed. His name
Filed.
has been reflected. Kindly,
Whose name is reflected?
Lordship. Kindly the delay may be condoned, Lordship. Paragraph number 10, 11, 12, I have specifically stated there were talks going on between the parties.
SS Ahmed. M. Alam. Wait for some time, he will inform the council.
Not
34.
Lordship, according to the last order, we see that today's method is for final hearing of the IA and the criminal division petition. A senior is on legs, your lordship. That's the basic.
Who is your senior?
GJ Sharma, your lordship.
Lordship, at two, we have some problems, Lordship. At two, we have some problems, Lordship. So, Madam,
After some time, let him come. After some time.
55.
My lord, with regard to item 32, my lord, I was on left, my lord. Item 32, my lord, we are going to file our objection, my lord. Item 32, my lord.
When?
Within 2 weeks, my lord. I am for the respondent, my lord.
Okay, date has already been given. You take the date from him.
Your Lordship,
You are in 35.
35.
Yes.
Your Lordship, I plead for an adjournment on behalf of the engaged counsel, Your Lordship.
This matter.
Yes, Your Lordship, 35. 35 scan copy of this here. Authorized on this copy.
Okay. Mr. Talukdar, learned counsel for the petitioner. Appearing on behalf of Mr.
P. Buttan.
P. Bhuttan, learned counsel for the petitioner. Price for listing the matter after.
Your Lordship, as per this court's convenience,
Comment.
preferably on a Friday.
Hmm.
25th August.
Preferably on a Friday.
So Borthakur learned additional PP submits that he has not received the case diary or case record.
TCR.
TCR submits that TCR has not yet been received in this matter. Accordingly, it is provided that receives a so urgent reminder to the learned trial court for transmitting the record.
Can it be on 28? 28 August. That's all.
Real hearings, item 17.
May I please, my lord, I'm extremely sorry, my lord, to interrupt, my lord. That item, missed item, my lord, 44. Kindly may be taken tomorrow, my lord, because urgency is there, my lord. Tomorrow is
No,
because.
already date has been
Yes,
given.
yes, my lord.
The other side has left the court.
My lord,
Sorry.
date has been given, my
Sorry.
lord, in the next week. Tomorrow, my lord, date tomorrow, my lord.
Sorry,
Tomorrow date, my lord.
not tomorrow.
Item 17.
May I please, your lordship? The charge sheeted matter, lordship, under lordship 20B. Lordship will kindly see the FIR on page 11, lordship. This person is a drug addict, lordship. He was arrested and no recovery was from him. And thereafter, on being asked, lordship, we have led to this
Page
second-
number.
page number 11. Lord. Read it, lordship, or lordship.
Not necessary.
Lordship.
When you have been arrested?
I was arrested on lordship 31-3, lordship.
31-3. And the case is registered under section
20B, lordship. Lordship, total amount, lordship, from the other person, it was recovered 2.520 kg, and later on from his shop 182 gram, lordship. Not from this person, lordship. The first paragraph of the FIR itself says about me, lordship. The first paragraph. This petitioner is a drug addict, lordship.
So, in the first paragraph, the quantum has not been mentioned.
Lordship?
Quantum of the contravention.
No, later part, Lordship. When he disclosed that he have purchased from the other person, the Raju, Lordship.
Where is the seizure list?
Page 34.
It's succeeded method. He says that what it says that case is pending.
From the present petitioner, initially, legal people, one Rana Mojumdar and Sardar Patri, legal people, they apprehended the accused. And thereafter, they handed over to the police station. And thereafter, on the basis of his statement, the present petitioner statement, my lord, another main accused associate, Raju De was, Sayan De was arrested. And from his, those drugs were recovered, my lord.
Drugs and ganja, Lordship. Page 34 is the seizure list.
Ganja initially 2.520 kg. And thereafter 0.18.
How many witnesses have been cited in the search sheet?
7.
7.
That was
Out of
independent
7, 2
witnesses.
examined.
Independent witnesses, Lordship, these two, and they were present at the seizure at the house of Raju, Lordship. And no whisper against us, and the cross was declined against us, Lordship. The first one.
Charge also framed under section 27 of the PSA.
The drug addict, Lordship, actually what happened, he disclosed that he purchased from Raju De, Lordship. This was the case, Lordship, that in the FIR it has been said, Lordship, that associate, Lordship, but he was not associate, I purchased from him, Lordship. He's a regular consumer of, Lordship, ganja, Lordship. He's a drug, he's a addict, Lordship, addict person. Clearly mentioned in the FIR itself. Seven, out of 7, 2 is it? We are behind the bar for last 132 days, Lordship.
So if you were enlarged on bail, then again you will indulge in similar activities.
So, Lordship, only my, I'm a addict, Lordship, not I'm a peddler, Lordship.
No, as per your own statement, you are being used by Raju De.
So that has been a statement, Lordship, that by the police, Lordship, and in actual fact, Lordship, he's an addict. I admit that part, Lordship. And the FIR itself says also, Lordship, I'm an addict, Lordship.
Part Mr. Munir, learned counsel for the petitioner. For the accused, and Mr. Das. No, Mr. Bortakur learned additional PP for the state respondent. This application under section 483 of the BNSS 2023 is prepared by accused Sujit Das alias Soton, who has been languishing in jail in connection with special NDPS case number 39 of 2026. Pending before the court of learned session judge Hosai, learned special judge NDPS Hosai, arising out of Lumding PS case number 48 of 2026 under section 20B within bracket Roman 2 within bracket capital B stroke 27 capital A stroke 29 of the NDPS Act since 1/4/2026. It is to be noted here that above noted case has been registered on the basis of one FIR lodged by one. Who lodged the FIR?
The police law.
WSI Rumi Thakuria on 1/4
Page 13, page
2026. The essence of allegation against the present accused is that on 31/3/2026, local residents, namely Rana Majumdar and Chandra Rai, apprehended the present accused, who is suspected to be drug addicted and involved in illegal ganja trafficking, and produced him at Lamding PS. And during interrogation, he reveals that his associate Raju De, alias Narayan De of Lamding Samajbari, has been engaging him in long-term illicit trafficking of ganja, storing of contraband in his house and shop, and selling it in Puria. And thereafter, a search was conducted in the house of Raju De, and 2.520 kg of suspected ganja was recovered from his kitchen, and also 0.182 kg of ganja was recovered from his shop, along with a sum of rupees 2,76,600 and one Jupiter scooty bearing number AS31E 0241. Mr. Moner, learned counsel for the accused, submits that the accused was apprehended on 31st of March 2026, and since then he is languishing in jail as for 132 days. Mr. Moner further submits that the accused is not at all involved with the offense alleged in the FIR, but he is a drug addict, and that after completion of investigation, search sheet has been submitted and trial is going on, and 2 witnesses have been examined so far, and that the accused will cooperate with the accused will face trial and will appear before the learned trial court on each and every date, and under such circumstances he is contented to allow this petition. Per contra, Mr. Borthakur, learned additional PP, has opposed the petition. Mr. Borthakur submits that the case has already been search sheeted, and 7 witnesses have been cited in the search sheet. Out of 7 witnesses, 2 have been examined so far, and that if the accused is enlarged on bail at this stage, it may cause delay in disposal of the case. But having heard the submission of learned counsel for both the parties, this court has carefully gone to the petition and the documents placed on record, and also carries the record of the trial court. And it appears that the accused was apprehended on 31st/3/2026, and he is behind the bar for last 132 days. Further, it appears that nothing has been recovered from his possession, but as per his statement, one Raju search was conducted in the house and shop premises of one co-accused Raju De, and 2.52 kg of suspected ganja was recovered from his kitchen, and 0.182 kg of suspected ganja were recovered from his shop premises. It also appears that trial has already begun, and out of 7 witnesses, 2 witnesses have already been examined. And since Mr. Monet, learned counsel for the accused, has assured this court that the accused will appear before the learned trial court on each and every date, this court is inclined to allow this petition. Accordingly, it is provided that on furnishing a bond of rupees 25,000 with one surety of like amount to the satisfaction of the learned special judge NDPS Pujai,
Lodge.
the accused shall be enlarged on bail in terms of this BA instance disposal.
Much obliged. Much obliged.
53.
পালেনি।
My lord, may kindly come to page 8, my lord, 1-8, my lord. Page 8. Para 9, my lord. It is,
Yes, Madam, there is a correction in the order.
I have no objection to that.
Okay.
But my
Heard
concern
Mr. Biswas, learned counsel for the applicant, and also heard Ms. Kumari, learned standing counsel for the CBA. This interlocutory application is referred by the applicant for correction of clerical mistake that crept in paragraph number
9.
paragraph number 9 of the order dated 7/8/2026. Mr. Biswas submits that in paragraph number 9, this court, while granting bail to the applicant, directed the accused to furnish bond of rupees 50,000 with one seriative like amount to the satisfaction of the learned special judge CBI court number 1, Kamrup M. Gauhati. But it, according to him, it ought to have been CBI court number.
my lord, it ought to have been special judge CBI
Special
Assam
judge
at Gauhati.
CBI Assam.
Assam at Gauhati, special judge CBI Assam at Gauhati.
Assam at Gauhati. Ms. Kumari, learned standing counsel for the CBI, submits that she has no objection. Accordingly, taking note of the submission of learned counsel for both the parties, this court is inclined to dispose of this interlocutory application by directing that henceforth the special special judge CBI court number 1, Kamrup M. Gauhati, appearing in the order dated 7/8/2026 in BA number 2106 of 2026 shall be read as special judge CBI Gauhati.
CBI Assam at Gauhati.
CBI Assam at Gauhati.
I am deeply obliged.
Standing item 4 for motion.
May it please your lordship.
Mhm.
The FIR is at page 22, your lordship. Lordship, may kindly come to page 22. If I may read your lordship.
Mm.
I have the honor to inform you that I have conducted an inquiry in connection with above reference. During the course of inquiry, I have examined the victims, namely so-and-so, so-and-so, and so-and-so, and recorded their statements. During examination, they have stated that they have received extortion money demand letters from Major so-and-so, Assistant Finance Secretary, Alpha Independent, at Lieutenant General so-and-so, Alpha, in order to raise funds for their organization. Among the said person, the victims received extortion demands letter of rupees so-and-so and so-and-so, respectively. The extortion demand letters received by them were also scrutinized. It is further revealed that apart from the demand letters, the said businessmen have been repeatedly threatened to WhatsApp calls from the mobile numbers so-and-so, where they were warned and that failure to pay the demanded amounts at the earliest would result in killing them and their family members. At the conclusion of the preliminary inquiry, it has been established that the businessmen so-and-so were subjected to extortion demands allegedly issued by Alpha Independent by two persons suspect to be cadres of Alpha, namely Major so-and-so and so-and-so. It is also suspected that some local active collaborators, on-ground worker, may be involved in facilitating such extortion activities. Therefore, I hereby lodge the FIR. This is the allegation, Your Lordship. I am not a named accused in the FIR, Your Lordship. But this FIR was registered under section 3084 BNS, read with 10 and 13 of UAP Act, Unlawful Activities Prevention Act, Your Lordship. So, and if these cases are registered under these sections of UAP Act, Your Lordship, then I don't have the right or remedy for anticipatory bail. But I have filed the anticipatory bail and resultantly I have to withdraw the anticipatory bail, and I am before Your Lordship seeking protection that no coercive measures may be taken at this stage because there are no prima facie material against me. I'm not a named accused. What happened in this case is, Your Lordship, this FIR was lodged on 27/3/2026. After 3 months, one Bidyut Buragohai was arrested. And he was supposed to be one of the collaborators, on-ground worker acting on at the behest of some alpha cadres, your lordship. When he was arrested, my name came up, your lordship. That is the only thing. So there are no prima facie materials against me, your lordship. And in similar matters, your lordship, a coordinate bench of this honorable court has already passed an order, your lordship. If your lordship may kindly come to page 33. In another case, your lordship. Page
Now,
33.
in this petition, what is your pair?
That no coercive action may be taken against me. That much only.
Lordship, I have to get the instructions, Lordship. Short date may be fixed. I'm
That-
waiting for the official respondents, Lordship. 1, 2, and 3.
Your lordship, similar matter has, in similar matter, order has been passed. Your lordship may kindly come to page 33, your lord. Annexure 5. This is also WP criminal. Your lordship got it, your lordship. Here the accused were named accused in the FIR. The only difference is I am not even named accused. Otherwise, same sections were there, your lordship. Now, if your lordship may kindly come to page 35, your lordship, once your lordship. This is the interim order passed. Mr. So-and-so, learned senior counsel, your lordship got it. The second paragraph of page 35. Page 35, second paragraph, your lordship. May I read? Mr. So-and-so, learned senior counsel appearing for the petitioner submits that the instant writ petition criminal is filed in view of the bar contained in section 43D, subsection 4 of the UAP Act in granting pre-arrest bail to any person accused of any offence under the said Act, and as such, urgent relief has been sought as per the mandate of the Honorable Supreme Court of India. So-and-so has relevantly cited the following judgment, 1, 2, and 3, your lordship. Then your lordship may skip the other parts and come to page 36. Third paragraph from top, your lordship, at page 36. Mr. So-and-so, learned government advocate appearing for the state respondent, submit that in connection with the case, the police has recovered some documentary evidence which implicate the petitioner with alleged offence. However, Mr. So-and-so seeks some time to file response after obtaining instruction from the authority concerned. And finally, your lordship may kindly come to
No,
page 37.
Mr. Sharma, you say,
Lordship.
here your only pair is to direct the respondent authorities not to take any coercive action. So
Yes,
what
your
is your pair? This is an interim pair.
lordship. Lordship, here I cannot come for quashing, your lordship. What happened in this case that I am citing before your lordship? They came for quashing of the FIR, your lordship. As an intermediary, they have paid for course that no course.
So here you are not challenging the FIR.
Because I am not even named, your
for
lordship.
quashing
So,
the FIR.
yes, I am not even at this stage. It will be premature for me to come before this honorable court with a prayer for quashing the FIR because there is no allegation against me.
So whether in respect of such interim pair, you can maintain this petition.
If your lordship is satisfied that since I am not a name accused and since there is a provision, there is a Supreme Court judgment also that in similar situation.
Okay, then let her obtain instruction.
In the meantime, I may provocate it. Your lordship may kindly come to page 37.
Lordship, till then, interim Lordship time.
I understand, your lordship may kindly come to page 37 once. Similar objections were made in this case also, in the earlier case also. Page 37.
No, that case is factually different from the present case.
I am in a betterly situated, I'm in a better position, you know, situated in a better position, you know. Because I am not even named. Here they were named accused, your lordship. Otherwise, the law governing both the situations are same, your lordship. And the Honorable Supreme Court has also stated that such a situation, if there is no prima facie allegations, materials found in the allegations of the FIR, your lordship, petitioner may be protected, your lordship.
No, that's all right. In Niharika infrastructure case, Supreme Court has laid down the parameters.
And subsequently, in such a situation where in Uttar Pradesh also there is no anticipatory bail under offense.
No, that's all right. That's all right. But
at page 37, this much order is required, your lordship. Similar matter, your lordship. no coercive action. I'll cooperate with the investigation if something come up. In the meantime,
No,
and
no, this decision referred by you, this court may not follow also.
yes, yes.
Because
yes,
of
course,
first,
Your Lordship. Yes, yes. I'm only praying because I have
the
annexed the
first and
document.
foremost question is whether this petition is maintainable or not. With such interim pair only. Okay, let her obtain instruction. We'll take it up on day after tomorrow.
Yeah, Lordship, I stay for a week's time, next week.
No, no, here there is apprehension of arrest.
Yes, Your Lordship.
Thursday. Or, no, no,
August, Lordship.
Lordship.
Can it be on 17th of August?
no, not so long then, because we are not granting him any interim relief today.
Lordship.
Therefore, heard Mr. Sharma,
Lordship.
learned counsel for the petitioner, and Ms. Devi
And
for
maybe
the, for the state respondent. In this petition, the petitioner has rightfully issuing direction to the respondent authorities not to take any coercive action against him in connection with Damaji PS case number 59 of 2026. In connection with the FIR dated 27/3 of 2026 under section 61, which will make it 2/308, which will make it 4 of the NS 2023, read with section 13 and 10 and 13 UAPA. The learned counsel for the respondent submits that she may be granted some time to obtain instruction before granting interim relief. Pair allowed lays the matter on Thursday at 2 p.m.
Obliged.
May I please, Your Lordship?
Yes.
Respondents are there, Lordship, so we are going to file our objection.
Pardon?
It's a condonation of delay, Lordship. And
You want to file objection?
It's a delay of 198 days, Lordship. Already there were talks. It was between a family. A check was issued. Loan was
You are appearing on behalf of
Private respondent.
respondent number? Private respondent.
Let us contest on merits, Lordship, the main criminal revision. The IA may be condoned, Lordship.
No, if you want to file objection, let him file. Because it is 198 days.
Lordship.
Heard Mr. Chaudhary, learned counsel for the applicant, Mr.
S.S. Ahmed, madam.
Learned counsel for the respondent number,
2, Lordship.
respondent number 2. Mr. Borthakur for the respondent number 1.
Lordship, yeah. State of Assam.
The learned counsel for the respondent number 2, respondent opposite party number 2 submits that he may be allowed to file objection in this matter and press for listing the matter on. Who is that you will be filed? You will able to file?
2 weeks, actually, even like 2 weeks.
No, not 2 weeks.
Sure.
1 week. 20.
Deeply obliged.
Pending 24.
Yeah, 2 p.m.
Lordship, if possible, Lordship, next week, Lordship, because we have some problem, Lordship, second half.
Okay. Is agreed by learned advocates of both the parties. Registrar lays the matter on next week.
Obliged, Lordship.
Pending 5.
Maybe, Lordship. Lordship is a criminal revision, Your Lordship. The order is at 16, Your Lordship, case number. Where the vehicle of the petitioner been released, Your Lordship, subject to furnishing of a bank guarantee, Your Lordship, of 10 lakhs, Your Lordship. On the last occasion, your lordship has instructed me to file the insurance copy, your lordship. So I bring on record that insurance copy by filing additional affidavit, your lordship.
So what is the value of the vehicle as per insurance certificate?
That is not there, your lordship. Insurance certificate.
Why it is not there? What is the certificate?
Orient insurance, your lordship. But it was written gross premium, your lordship, 19,480. That is premium, your lordship. Otherwise,
No, where is the certificate? Insurance certificate.
it's the policy, your lordship.
Where is that policy?
I have annexed with the additional affidavit, your lordship.
So it is not there.
Additional affidavit.
Annex of 4. Annex of 4 is not here. What category?
Additional affidavit.
No, you have not enclosed it. You see, you check the affidavit. Next slide.
Landing 18. Oh, sorry, 18.
Your lordship,
Members of the accused. Okay, you go through the same. We will take it up later on. After some time.
lordship.
21.
None appears for the accused on call. However, Mr. P. Botha, Mr. Goswami learned additional PP present. List the matter. After a week, in the event of subsequent non-representation of the accused, appropriate order shall follow.
Item 22.
Maybe there's lots of it. This year was called for, but it is not available.
Heard, Mr.
B. Kumar on behalf of ABT.
Learned counsel for the accused and also heard Mr. Goswami, learned additional PP for the state respondent. The office note dated 7/8/2026 indicates that scan copy of the TCR has not yet been received. Accordingly, it is provided that registrar shall issue urgent reminder to the learned trial court for transmitting the scan copy of the record. List the matter on.
Lordship, the notice issued was served. The notice issued on respondent number 2 is served.
We have received the instruction.
Mr. Goswami and learned additional petty apprised this court that he has received instruction in respect of service of notice upon respondent number 2, but no one entered appearance on behalf of respondent number 2. Accordingly, Sangita Soikya be appointed as amicus to represent the respondent number 2. Rest shall reflect the name of Ms. Sangita Soikya in the cause list and also furnish the relevant papers to her well in advance and list the matter on 25th.
23.
Yes. My lords,
Today is the 50 days in jail, my lords.
Pardon?
Today is the 50 days is in jail, my lords.
50 days.
The 50 days, my lords. The child marriage between sections of the postcode, my lords. And they have the little child also born, my lords. That's the alleged victim. She is now more than 18 years, and she has filed a affidavit in this case. My lords.
She has filed affidavit.
No, this affidavit by the victim, that she is now 18 years, and so page number. Page number 10 in the affidavit. The FIR, my lord. Page number 11.
So search sheet is submitted and not submitted. Investigation is going on.
You have to respond.
Okay. You have filed objection here? No. What is your submission? Okay. Yes, Goswami.
She was minor before attending a rate of 60. Now she is major, my lords. Now she is major.
Of Satsapuri Dolani, please. Under Mayong PS. And kept her in his house at Kahikusi, and the girl delivered a baby boy about 3-4 days back at GMCH Bhamagar. The learned counsel for the accused submits that this is a case of child marriage and that there was affairs between the victim and the accused. And the accused, he loved her and got her married, and they were blessed with 1 children also. And that the accused is ready to cooperate with the investigating agency, and under such circumstances, he is contented to allow this application. Mr. Goswami, learned additional PP, however, opposed the petition, producing the case diary. Before this court, he submits that the victim in her statement under section 183 of the BNSS 2023 has implicated the accused with the offense alleged. The learned amicus also submits that the informant has no objection in the event of enlarging the accused on bail. Having heard the submission of learned counsel for both the parties, this court has carefully gone to the petition and the documents placed on record and also perused the case diary produced before this court by the learned additional people. In view of the materials collected so far in the case diary, especially the statement of the victim girl recorded under section 183 of the BNSS 2023, and also in view of the submission of learned amicus for the informant and the progress of investigation, this court is of the view that further custodial detention of the accused in the interest of investigation is not warranted in this case, and accordingly, this court is inclined to allow this petition. It is provided that on furnishing a bond of rupees 25,000 with one security of like amount to the satisfaction of the learned. Where it is pending now?
My lord, this is the postal code special.
Learned
Postal code,
special
the
just
Kamrup
Pokso Morigaon.
No, my lord, Kamrup.
Kamrup and Gauhati, the accused be enlarged on bail, CDB return.
Item 24.
Obligement. My lord.
Well, the petitioner was arrested on 12/7, my lord. 26 case was registered under section POCSO also, my lord. And notice served, my learned friend appeared on behalf of the informant. My lord, the petitioner is behind the bar since last 30 days. Today, my lord, 30 days, my lord. And there was a, my lord, victim and the petitioner. My lord, both the families are, my lord, arranged their marriage actually. Victim was supposed to get her married, my lord, after attaining the age of majority. In between, my lord, something happened between them, my lord. And so, my lord, she became pregnant. And, my lord, when the
You are not amicus here? Learned counsel for the informant, respondent number 2. This petition under section 483 of the BNSS 2023 is prepared by accused Rupal Sinha, alias Rupa Sinha, who has been languishing in jail since 12/7/2026 in connection with Patasil number PS case number 104 of 2026 under section 87/89 BNS related section 6 of the POCSO Act for grant of bail. It is to be noted here that above noted case has been registered on the basis of one FIR lost by 1. Rupali Boro, alias Deka, within bracket, actual name withheld, on 12/7/2022. The allegation against the present accused is that he has affairs with the minor daughter of the informant and he impregnated her and due to some complication, she was admitted at Gauhati Medical College Hospital. And the doctors of GMCS inform her that her daughter has been carrying pregnancy of 1.5 months. Mr. Colita, learned counsel for the accused, submits that there was affairs between the accused and the victim, and the accused is languishing in jail for 30 days, and the family members of the accused and the victim have decided to solemnize the marriage of the victim and the accused once the victim attained the majority, and that the accused is ready to cooperate with the investigating agency and therefore it is contended to allow the allow this petition. Mr. Goswami learned additional PP or oppose the petition. For this in the case that before this court, he submits that the victim girl in her statement under section 183 of the BNSS 2023 has implicated the accused with the offense alleged in the FIR and that investigation is going on. Therefore, he is contended to dismiss the petition. On the other hand, Mr. Dr. Learned, counsel for the informant, respondent number 2, apprised this court that the informant has no objection in the event of enlarging the accused on bail, as negotiation between the parties are going on to settle the dispute amicably. Having heard the submission of learned counsel for both the parties, this court has carefully gone through the petition and the documents placed on record and also perused the case diary with the assistance of Mr. Dr. Mr. Goswami learned additional PP. It appears that the accused is languishing in jail for last 30 days. Investigation has progressed in the meantime significantly. Further, the evidence, the statement of the victim girl recorded under section 163 of the BNSS 2023 indicates that she has affairs with the present accused. And accordingly, taking note of the taking note of the submission of learned counsel for both the parties and also considering the period of detention, this court is of the as well as the progress of investigation, this court is of the view that further custodial detention in the interest of investigation seems to be unwarranted here in this case, and accordingly this court is inclined to allow this petition. It is provided that on furnishing a bond of rupees 25,000 with one surety of like amount to the satisfaction of the learned special judge Pakso Gauhati.
Yes, ma'am.
The accused be enlarged on bail. The CD will return.
Item 25.
Obliged.
If I proceed as for dated 17/26, service report is awaited.
Heard, Mr. Islam learned counsel for the accused. F. Mr. Goswami learned counsel for the learned additional PP apprised this court that service report upon respondent number 2 is still awaited.
You have received the case report.
However, he submits that he has received the case diary. List the matter on
Short date loan. Otherwise, 39 days in custody.
sorted. 19th.
Lordship.
List the matter on 19th. And on that day, Mr. Goswami shall produce the service report before this court, having obtained the same from the officer in charge jurisdictional PS. List accordingly.
Lordship. CD may be retained, Lordship.
Children CD be retained.
Lordship. Deeply obliged. Obliged.
May I please your issue? He is behind the verse since 18 June, Lordship.
Yeah, CD was called for.
Kindly see the page number 20
You were behind the bar for
from 18th June, Lordship.
so these offenses are 60 days offense or 90 days.
Lordship, there is 147 and 148 there, BNS.
What is the punishment?
There is death and life imprisonment.
Death or life imprisonment. So
Lordship, kindly see the page number 24, Lordship.
let the CD come. Heart miss your name, please.
G. Talukdar.
Learned counsel for the accused and Mr. Goswami learned additional 50. Mr. Goswami submits that he has not received the case diary and plays for granting him some time to produce the same. Bear allowed, list the matter on 18th. On that day, Mr. Goswami shall produce the case diary before this court.
27.
In this case, my lord, an innocent man is in jail, my lord, since 18 July, even without committing any offense, my lord. But kindly moment for a moment, kindly see FIR page 15, my lord.
Without committing any offense.
Yes, my lord, page 15.
Then why
kindly
he
see.
was arrested?
I have been arrested, my lord. Police found information that
Case
seven,
diary received, Mr. Borthakur?
Not received, my lord. One report from the IO I have received, my lord.
Hmm.
CP is, my lord, lying in the court of, my lord, additional session judge still moving, my lord, regarding some other case, my lord.
for a moment, kindly see the FIR and my grounds, my lord. Why I have been arrested, my lord, and why I am in jail. Kindly see the FIR, my lord, page 15. My name has been erased as accused number 4, my lord. Not all petitioner before your lordship.
So you have been found in possession of the cattle.
Now, my lord, kindly see para 3, para 5, my lord, page 3. I am the owner of a single cow, my lord, for which I have a receipt, my lord. I am, my lord, Aftabur Rahman Chaudhary, who is arraigned as accused number 4.
No,
And
no.
I am the owner of a one cow, my lord, and for which I have a, my lord, bona fide receipt. Kindly see, my lord, page 3, para 5, my lord. I have annexed this one. How I have been, my lord, implicated with other 3, my lord.
That is your statement.
My
That
lord,
has to be
I
verified from you.
have my lord, original receipt, I have, my lord. This receipt, kindly see, this is the receipt original. I have annexed the Xerox one, this is the original receipt. This is the original receipt issued by the registered cattle market. It is a registered cattle market. That I have annexed, my lord. Page 21 and 22. Kindly see, this is the statement I have, my lord, specifically mentioned, my lord. I am the owner of one cow. And already,
No, no, that is your statement.
this is the, this is
And you were
substantiated,
the accused.
my lord, this is substantiated with the document, my lord. This is the
No,
original
whether
document.
verification of that document is not required to arrive at a conclusion that you are innocent.
My lord, kindly see this document, my lord. This is the original one, my lord. That
No, how can we ascertain that that is original document?
because this is the, my lord, this is issued by the Kaligans Gau Panchayat,
Hmm.
and this is, my lord, seal and signature, every
Let the
serial
PD
number is
come.
there, my lord. So at this stage, my
We'll
lord,
see
already, my lord,
you are innocent or you are accused.
24 days in custody, my lord.
Maybe. What is the punishment prescribed for the same?
3 years, my lord.
Yes.
3 years. And 24 days today, my lord. Is in custody, my lord. 50 years.
And
old.
section 13(1) of the Cattle Preservation Act.
Yes,
What is
my
the
lord.
punishment?
That I have, my lord. Section 13, my lord, it is 8, may extend to 8 years, not less
May
than
extend
3
to
years.
8 years.
Not less than 3 years, and may extend to 8 years.
Then
So, my lord, my humble submission, 24 days in already in custody. my lord.
maybe, but we have to peruse the case diary. Borthakur, you ask your IO to collect the CD and produce before this court.
My lord, considering this act, my lord, considering this, my lord, petition, my lord, your lordship in earlier occasion given a short date, my lord. Because of my lord, the innocence, considering the innocence of my client.
That's all right, that has to be verified.
But
That has not been
Who will
submitted.
fix the sorted? Heard Mr. Acer Soduri, learned counsel for the accused, and Mr. Bortakur, learned additional people. For the state respondent, Mr. Bortakur has produced one WT message from the officer in charge of Sribhumi PS. And on the basis of the said WT message, he submits that the case diary is not available in the PS and it was submitted to the learned additional district and sessions as FSC Sribhumi. Accordingly, it is provided that Mr. Bortakur shall produce the case diary before this court on next Monday. Without fail.
Obliged.
Item numbers 47, 51, by VC notes.
I am for the petitioner in item number 48, Lordship. Can the matter be taken up after some time, Lordship? Pass over for the time being, Lordship.
48.
8.
Why?
My senior Mr. S. Das was supposed to appear, Lordship. I'll have to inform him, Lordship, about the matter being raised.
You inform him,
He was-
we will hear the other side or
Yes, sir.
other matter.
Yes.
Yes, Mr. Kato.
My lord. My lord, yesterday lordship has already
Yes.
heard the bail application, item number 47, 50 and 51 lordship.
Yes.
Only the CD has to be produced.
Okay, Mr. Gogoi, CD is available with you?
Yes, sir.
So what is the stage of investigation?
Investigation, my lord, almost 7% has been now been arrested. 7% has been arrested. One has been granted bail, my lord. He was a advocate, their counsel, my lord, he was also arrested.
No, stage of investigation, is it about to complete or there remains
My
to?
lord, in fact, one has been arrested last week, my lord. So cross interrogation is going on, my lord. Even one of the main accused has been, my lord, sought for, my lord, remand for another 3 days. That has ended, my lord, yesterday, I suppose.
No, so far the present accused persons are concerned, whether their further custodial detention is warranted in the interest of investigation or not.
Lordship, in fact, my lord, I have a note. Bail objection note, my lord, from the IO itself. The lordship may have a look at that. Against, my lord, all the, my lord, petitioners who are before the honorable court. This particular note has been provided by the IO. Lordship will see, my lord. Serial number 2. He is the, my lord, petitioner number. Our case is item number 49. Serial para number 2. Para 3 relates to, my lord, 48. Para item 48.
No, the present accused persons,
Yes, sir.
being represented by Mr. Kato, two of them are residing at
Yes,
Calcutta.
my lord, that is, my lord,
South.
47, 50 and 51. 47, my lord, is serial number 4. And item, my lord, 50 is serial number 5.
And 51, item number 51.
51 is serial number 5 and 50 is serial number 6. My lord, so far as Ajay Kumar Yadav is concerned, my lord, everything, my lord, his detail has been provided. He was an employee, my lord, he's the caretaker. Of 3, my lord, funds. One was registered in name of, my lord, Sahina Sultana, serial number 2. Main proprietor. And another other 2 are in the name of serial number 5 and 6 of this letter. Now, my lord, so far as 5 and 6 is concerned, my lord, there is statement in the before the IO is that, my lord. So far as the box is concerned, my lord, he is no way involved, my lord. He some, my lord, he deals with some, my lord, business of selling flowers and all, my lord. And this, my lord, other accused, my lord, they took his pen number. his Aadhaar card and all, my lord, took some blank signatures. It is there in the statement. And in his name, this firm was operated. And some 5,000 or something was provided to him every month.
Deepak Saw.
Deepak Saw and my lord Jitendra Saw. Two firms are registered in their name.
Okay.
Jitendra Saw, my lord, he is a my lord, he's a courier of my lord, Blinkit and all, my lord, home delivery. So same has happened with him. Some my lord, PAN card and my lord, Aadhaar card was procured from him. Blank signatures were taken and 5,000 every month, that was the deal. He is totally unaware what has happened, how the firm is operated, who is operating. That is his statement, man. In fact,
So,
other-
according to you, these two persons, further detention of these two persons are not warranted in the interest of investigation.
Lordship, the IO has otherwise claimed for my lord custodial interrogation, my lord, or detention as on this. That I leave it to your lordship. So what I could gather
Okay.
from this my lord statement.
Okay.
So far, these two persons are concerned, poor person, my lord, 5,000 they are getting, they are doing my lord petty jobs.
Hmm.
And my lord, in lieu of that, my lord, they are now behind the bar. That is what transpired. But my lord, Yadav is concerned, my lord, he is my lord operating all these three firms in the state of Assam. That is my lord item number 47.
Hmm.
Serial number 4.
Hmm.
Lord, you will find their statements in my lord in the case diary.
Hmm.
And my lord, the prime accused in this case, my lord, is one has been arrested recently. And another is my lord, Shahbaz Haider. He is the main accused, as well as one my lord, Vinit Poddar, who has been arrested on the last week.
Hmm.
His statement is there, my lord. Lordship will have to go through, my lord, their statement first, my lord, in order to corroborate with the statement of this, my lord, petitioners were before the honorable court.
Hmm. So, according to you, against Ajay Kumar Jadhav,
My lord, serious
some
allegations
materials are
He
there,
is directly involved, my lord.
directly
He
involved.
is the main operational head, my lord, in the state of Assam, of these three firms. On behalf of my lord, this Haider, Shahbaz Haider, and my lord Poddar and all, my lord, Vinit Poddar, who has been.
No,
recently
that's all right. So materials are there, all right. But what is the stage of investigation? Whether his further custodial detention is necessary?
My lord, when my lord, there is one more accused who is to be arrested, my lord, who is absconding as on date. My lord, moment they are arrested, my lord, probably his custody will be necessary to my lord cross-examine my lord their part, and all are from my lord Bihar. So moment probably they are released. To have them here for trial and also is another question, my lord.
Okay.
For the sake of
Okay.
investigation.
Okay. Mr. Kato,
My lord,
we'll go through the case diary and we'll pass the order.
my lord,
Okay.
my lord. My lord, since I am ready to cooperate with the investigation, my
Yes,
lord, I
all
am
right.
almost, my lord, detained in the custody for last 2 months, my lord. Only 4
Okay.
days left, my lord.
And my lord, huge, my lord, evasion of taxes there, my lord, in the name of fraudulent input tax credit.
49,
My lord, deep replacement. Deep
49.
replacement.
48,
48 Nosrat, my lord, he is one of the prime accused.
Well, I am appearing for Nosad, my lord.
Hmm.
My lord, if your lordship will kindly see the grounds, my lord. He is neither the proprietor, my lord. The grounds of arrest, my lord, at page number 23. He has completed 57 days, my lord, till date.
Page
And
number?
for 23, my lord, the grounds. My lord, he is not the proprietor, my lord. He, as per my instruction, my lord, he only dealt with the transportation part of the business, my lord. Page number 23.
Hmm.
And there is not a single statement, my lord, which indicates that the present petitioner, my lord,
Not a single statement.
yes, in the grounds, my lord, which shows that, my lord, the
No,
petitioner
no,
had filed.
statements are not available with you. It is in the case diary.
No, no, grounds, my lord, grounds.
Hmm.
Page number 23.
Yes.
It does not show, my lord, that the petitioner had filed any false GST claims, my lord, or, my lord, generated fake invoices, my lord. As per them, my lord, we only preserve the records, record keeping part. But actually, my lord, the petitioner, my lord, overlooked the transportation part of the business, my lord, and he received a fixed salary of 30,000 per month.
Other than that, my lord, he is not in any way involved in the, my lord, financial activities of the business, my lord, that is IDA. So my humble submission is that, my lord, since it's entirely a, my lord, documentary, well documented investigation, my lord, since most of the part of the investigation has already been concluded and the documents have been seized, so further, my lord, custodial detention of the present petitioner may not be required, my lord.
Okay.
And if your lordship will kindly have a look at page number 19, the FIR, my lord. At third paragraph, last line.
Page number?
19, my lord. FIR, third paragraph, last line.
Yes.
It says that, my lord, as per information, documents relating to fake invoices are maintained by Shahbaz and his brother Nosat. Shahbaz is the proprietor, and they say that, my lord, he is the brother, but actually he is not the brother, my lord. Shahbaz is the, my lord, manager, de facto manager.
Okay.
Possible see, my lord, para number 3 of the bail objection, my lord. He is involved, my lord, in one of the prime accused, my lord. He looks after the business of the 3 funds, my lord. And he is also involved in preparing the bills and all. Purchase bills. Now, my lord, these 3 firms, my lord, they show that, my lord, goods are sold, are being sold from a particular firm. And to another firm that is also, my lord, within these 3. And it is same office, my lord. Bitumen, my lord. They deal with bitumen. There is no actual transport, my lord, at all. Lordship will see the, my lord, statement of the, my lord, main tax officer, my lord, who has investigated this part thereafter he has lost the FIR. His statement is there, my lord. Every detail has been given, my lord, how they used to operate. There is no actual sale, no transport of goods from Kolkata to Assam, to state of Assam. Only on, my lord, papers, nothing on physical, my lord, delivery is there.
Okay.
And on lieu of that, my lord, they used to get the benefit of input tax credit. Whereby, my lord, by that credit part, my lord, they are exempted, my lord, from paying or their tax is, my lord, adjusted on that particular part, my lord. Say, supposingly, my lord, input tax credit is, my lord, 1 lakh, the tax is 2 lakhs, that 1 lakh will be adjusted from that. This is how, my lord, about, my lord, 17 crores, 8 crores, my lord, of this fund, my lord, they have now, my lord, fraudulently, my lord, misappropriated those, my lord, amounts, my lord, of the state of Assam.
Okay.
He is, my lord, main accomplice of, my lord, the main accused. There was this no, sir. The lordship will find this statement, my lord, in this particular part. Lordship will also, my lord, have a look at the statement of Seva. He has stated that, my lord, he is one of his co-accused, my lord, in the entire business. No,
Okay.
sir.
Okay. Okay, we'll see the case that
My lord.
pass the order. In other item.
Highly obliged.
49.
Aina Sultana, my lord, she is the wife of Seva Haider. She is the proprietor of, my lord, Ida Bitumen.
49.
49.
Mr.
I have read their statement, my lord. Record. Lordship, may have a look at the statement of the, my lord.
Mr. Das, you are also appearing in the other item.
49.
No, my lord.
No.
A Mishra. A Mishra.
Mr. Gogo, you keep the case diary with the court master.
My lord. Just may I point out the flag, but that for your
Okay.
information.
Okay.
But the pink one, my lord, the statement of the, my lord, tax official, my lord, will investigated this department, my lord. Yeah, flag month, my lord. His name is, my lord, Divya Ranjan Bora, the informant, my lord. Divya Ranjan Bora.
No, regarding this Sahina Sultana.
Yes, that, my lord, of all the petitioners, my lord, of this particular series of case, I have flagged my every
Okay,
case.
okay,
By name, my lord,
Okay.
wherever that person
Okay.
appeared, my lord, I have flagged my.
okay.
And lordship may also, my lord, peruse the statement of Vineet Poddar, who has been arrested last week. He has
Okay.
also made that.
I'm sorry, Lordship. Item number 34, when it was called, Lordship, I was on legs, Lordship. It was fixed for final disposal today, Lordship. We prayed for some time, Lordship, time being, but they did not agree, Lordship. Can a date be fixed? A date has not been fixed. Any day in this week, it was fixed for final disposal.
Take a date from him.
Yes. Deeply obliged.
May I please the, my lord?
Okay.
May it be pleases you, Lordship. On the first of your Lordship, my item is item 21, your Lordship. That is Karnam Bhumij, your Lordship. I'm representing as legal aid counsel, your Lordship. That
Okay.
matter is,
We have already fixed the matter. After 1 week.
can it be on your Lordship Wednesday? This coming Wednesday
Tomorrow is Wednesday.
or Friday to no Wednesday. Tomorrow. Already, your Lordship, 2 years has been passed by, your Lordship. He was behind the jail, your Lordship. Arrested. Nothing has been found, your Lordship.
Day after tomorrow.
Thursday. I'm deeply obliged.
Standing item 49.
My lord, first of all, I apologize, my lord. There's total miscalculation on my part, my lord. I'm so sorry, my lord, actually, my lord.
No problem.
No, sir. My lord, in this case, kindly, lordship has seen the FIR, my lord. Please come to page 21, my lord. I am for the Shaheen Sultana, my lord. Shahina Sultana. My lord, this is lordship has seen the FIR. I will not disturb your lordship. Please come to page 23, my lord. Page 23 now. Bottom, my lord. Last
Yes.
part, it is further mentioned pertinent. Let me read this one. It is further pertinent to mention that Mohammad Shabaz Haider, Patna, heavy mobile number such as is one of the major coordinator of illegal trade of bitumen on the basis of fake invoices. And on the farm of Bihar where such and such in export. Shabaz Haider has floated farm named MS Assam, the Ada Bitumex, Pointum such and such. As per information, this is important, my lord. Documents related to the fake invoices are maintained by Shabaz and his brother Noshat, my lord. That's what written. I am, my lord, wife of this Shabaz, my lord. What has even lordship knows, my lord. Most of the people in their wife's name, they are homemaker basically. They register the farms in the name of the wife, thinking, my lord, this may be very lucky. Some people. That's what they have done. Here, my lord, he has operated. Basically, she is a total homemaker. Except these things, she has no knowledge, and they have written here, my lord. It is this Shabaz and Noshat, they are the managing. Now, please come to page number 38, my lord, the forwarding report. I'll be in short, my lord, since your lordship. Page 38. This is the forwarding report, my lord. Second paragraph, my lord, fourth line. Second paragraph, fourth line, right side. The investigation. Lordship has got it, my lord. The investigation by the state GST officials further indicated that Amit Kumar Jha exercised effective control over the affairs of the farm MS Assam Bitumex and was instrumental in conducting all official proceedings related to the state farm. That's the reason I want to say, my lord. I am the homemaker. Yes, true. It's very much true. The farm is even my name, my lord. But it is being run by Lord Lordship has seen the last 2 pages by the 2 persons, and here also this Amit Kumar. This Amit Kumar has been granted bail by this honorable court, my lord. Now, my lord, this is another issue now. Lordship will find, my lord. I was already in 8 days police custody from the date of arrest. I was in 8 days, my lord.
So for how
Then, my
many
lord,
days you are behind the bar?
57 days today, as of today.
57 days.
Yes, my lord. 57 days.
What is the punishment prescribed for the?
My lord, for that that life imprisonment, 338. 338, my lord, you will also get it, 338 and 336, 3, these two. One is forgery for cheating, 7 years, non-bailable. 338, forgery for bailable security, life or 10 years, my lord. There is a maximum punishment, other are bailable, my lord. So basically it's 90 days, my lord. So what happens, my lord, here, I am already 57. And second point is, my lord, I have got a minor son who is just 5 years old. And right from his birth, my lord, he's suffering from neurological problem. He was being treated in Patna and then Nimhans, my lord, Nimhans in Hyderabad, my lord. He's still under treatment. I given the certificate here, my lord. And my lord, another issue I just want to bring to your kindly notice, my lord. 480, my lord, section BNSS 481, my lord. Just Lordship will look once, my lord. 480. Lordship is aware of this fact, my lord. There is some special protection for the minor and the wife, the woman, my lord. Judgment by the law. 480. Just let me read that, my lord. 480.
No, not necessary, Mr.
My lord, my lord. So basically, my lord, Lordship will consider, my lord, she is in 57 days in custody, and she has got a minor son and also a daughter who is in class 7, my lord. Now, in their absence, father and mother, both of them are in the jail, my lord. 57 days she is in now. Now, this minor son, especially, my lord, he is a sick boy actually, not well since childhood. It's his birth, my lord. So this part may be looked into, my lordship.
Okay.
And my lord, only one issue, my lord. This Amit Kumar Jha, he has been granted bail. And also, my learned friends, my lord, in PP, in session court, learned session court, they made submissions that custodial interrogation is not required now. They are apprehending only now. If in future, if some documents are available, my lord, that lordship will take care, my lord, if that is.
As far as co-issue Amit Jha is concerned, he was the, my lord, their counsel, he was the advocate. Not a, my lord. But it is so on that ground, my lord, he was granted bail. Therefore, after 14 days of 45.
And direct allegation against him.
The petitioner is concerned, my lord, he is the direct beneficiary of this, my lord.
Obviously, it's my name. I'm not saying no, because farm is in my name.
And my lord, the state exchequer, my lord, directly has been hit by this action, my lord. And it's a big, huge racket, my lord. And
চন্দন আর
lord,
ইয়ে দেও তো,
from
জানো
the
তো,
various
কাগজটা
statement
দেও,
of the
জাগরটা দেও।
arrested accused, my lord.
চন্দন দেও না,
Her
এখান থেকে
name
দেও,
is,
জাগরটা দেও।
well, her name to be one of that police. That lord, civil, my lord.
My lord, lordship has got that Amit Kumar just bail order.
He is an advocate, my lord.
Yes, but his name is beat দেও না।
45 days he was.
Amit Kumar and Chandan, my lord, these two lordship may can let me look once my name. Because in their application, they have said, my lord, they are the managing in the affairs, and Amit Kumar Jha also. Only because I am a wife homemaker, my name, my lot of people doing their wife's name, my lord. That's what my lord.
We'll see and pass the order.
My lord, my lord. This is Amit Kumar Jha, Chandan, my lord. Obliged, my lord.
Standing item 2. Here, my lord, IO is DSP, my lord. Forwarding report till 15 case. IO is, my lord, one.
IO is Piketeka,
Yes.
where it is mentioned.
Page 20, my lord, that is forwarding report. Page 20. Investigating officer of the case.
Page number 20.
20.
Okay.
That was my initially preliminary inquiry was done by the that's what the
Lordship, as per section 15, Lordship, special officer must be present at the time of Lordship raid, Lordship. Moreover, Lordship, as per FIR, Lordship, police have letter claim, Lordship. Number 14, Lordship. May I read, Lordship? Page number 14, Lordship. সন্মানপূৰ্বক বিনীত নিবেদন এই যে যোৱা বহুদিন ধৰি উক্ত আছামী দুজনে বৰপেটা ৰোড টাউন IDBI বেংকৰ ওচৰত মিৰৰ চেলুন এণ্ড স্পা নামৰ এখন দোকান খুলি উক্ত দোকানত নানা ঠাইৰ পৰা বিভিন্ন ছোৱালী ব্যৱসায় চলাই থকাত ইংৰাজী 28/7
How long you are behind the bar?
14 days, Lordship, till today.
14 days.
Lordship, coordinate bank also.
When the case was registered?
Case was is on 29/7/26.
Yes, Mr. Bhattakar, anything to investigate and recover in this matter? CD. So when you will be able to produce the CD? Monday, next Monday, CD.
17th. I'm getting 5.
No, Lordship, my apology, Your Lordship, my clerk failed to annex that, Lordship, insurance, Your Lordship, may kindly allow me to annex that insurance policy, Your Lordship, and fix it, Your Lordship, tomorrow or day after tomorrow, as per the convenience of this honorable
Tomorrow.
court, Your Lordship.
Okay, on the appeal being made by Ms. Zibora, learned counsel for the petitioner, raises a list the matter tomorrow. So as to enable her to enclose the insurance certificate of the seized vehicle. They are allowed, raise the matter tomorrow.
Friday, Lordship, Friday I'm not available, Your Lordship, can it be on Thursday, Your Lordship?
Thursday,
Thursday, Your Lordship. Much obliged, Lordship.
Timing 18. Timing 18.
Your Lordship, I'm supplying this Mihir Ranjan case also, Your Lordship. Yes.
CD part of it, the specific notice not there.
Your Lordship, I-
regarding,
Part 48.
no, regarding furnishing of the ground of arrest to the relative.
Yes. It's what the arrest memo is there, okay, and signature of the accused wife is there, okay, but 47 notice also there, 48 notice, the signature was not there. Wife of the accused.
Your Lordship,
On that part of it, there is no, I don't find note regarding that service of notice we compared, but the trial court order, when it is being produced, the trial court. The observation is there.
No, is there any observation in this judgment
Yes,
that
I'm-
signature has to be obtained?
Yes, Your Lordship, at
Where?
27, Your Lordship, paragraph
Pardon?
number 27, Your Lordship. And Your Lordship, paragraph number 247, Your Lordship, I have highlighted, Your Lordship, at the top of the judgment, Your Lordship. And reiterated the provision, Your Lordship, at paragraph number 20, Your Lordship. Even, Your Lordship, the Bihan Kumar case also noted, reflected that portion, Your Lordship.
No, no, that is there, that family members has to be informed.
Yes, Your Lordship,
But,
that is clear, because otherwise the
Is
mandate
it
of.
mandated that signature of the informed person has to be obtained?
My ground is that, with due respect, Your Lordship, that notice was not served to me, Your Lordship. Not signature, Your Lordship. My ground is that that ground notice is not served to me, Your Lordship. And Your Lordship, that is a false allegations, Your Lordship. Otherwise, the child was raised by the petitioner, Your Lordship. Please tell you.
Yes, sir, that was on the basis of one report submitted by the superintendent of Central Jail.
CCTV status of the central jail.
Yes.
That my officer has done. In fact, what I gathered from the officer is, the work was given to the firm in the month of.
No, the question is whether it is functioning as on date or not.
No, but the recording part is not complete. For the recording, I have asked him, the installation of the camera have been done, and then the recording part for license is required from the particular company, boss and law, and they are in the process of submitting the ultimately fund has to come. So that process is on. Recording is not available.
So what purpose will be served if the recording could not be done?
That's true. Recording, one of the licensee, the license part is from the company has to come, then only the recording will be preserved. Now, the
Otherwise, the cameras are there and they can monitor what is going on now, the real time. But recording will not be present for future at this stage, because the work is not yet complete. So when it can be expected that the entire process will be completed? But I have asked him, and also I have talked to the IG result. The estimate from the company, they are expecting by tomorrow the estimate will come from the company. How much for renewal, because they have some pending liability also, so the entire estimate will come by tomorrow, they said. Then one of the PWD will send it to the IG results. Then IG results will do expecting within a month, we are expecting. Within a month.
May your lordship,
Yes.
in accordance with Supreme Court guidelines, 24-hour CCTV surveillance is mandatory in every jail. Any violation of this directive will be considered contempt of court violations.
In which case?
Yes, your lordship.
In which case it was directed?
Your lordship, 2015 under a landmark judgment, Dilip Kumar Basu vs State of West Bengal, the Supreme Court of India mandated the installation of CCTV cameras in all prisons nationwide compulsory. Lordship, also under Article 226 of the Constitution of immediate intervention, transfer of investigations or departmental action against the negligence of these officers, public servant. May your lordship, can I file affidavit? Can I submit additional affidavit on this regard?
Okay, all right.
And
But,
may your
sir,
lordship,
does you see this, if recording part is not there, then what purpose will be served? But now the allegation is, you see, the lady, she has been subjected to torture by some persons there, antisocial elements there. So had there been recording, then it could have been arrested the person responsible for the same. I have that indication I have seen. Exactly, one of the recording, at least for some time, that it is necessary. I have seen that. Now the what is going on in real time, that can be only viewed. The recording part is not available as of today because of the upgradation of the system. At the time of the issuing of the work order, it was only for repairing, installation and repairing. But this part, I don't know that somehow the license part from 2021, some fee is pending with the company, licensing company.
may your lordship, after arrest jailer Debokamal Borua and 2 constable, February month. After that, they are not doing the same. They all, the jail authority reveals that corruption is openly within the operating openly within the jail, Central Jail Gauhati. They are running their own agenda in complete disregard of this honorable court and the Supreme Court. By siding with the criminal, they too became criminals. Everyone is involved in this conspiracy to kill me. It is very important to highlight, CM sir, about these matters as soon as possible, Your Honor.
Okay, you file an affidavit, we'll see.
Yes, sure, Honor. Sure, Your Lordship can.
Mr. Das, we will, in this matter, we will monitor
Lordship.
the progress of the work. So, we'll fix.
Your
after-
Lordship, this is a mob lynching incident. 20 people are attacking continuously in entrance, but no one helping me, even till that. They want to kill me because I
Okay.
fight this battle.
Okay, you file the additional affidavit, we'll see.
Short, kindly allow short date.
One thing I was just
going through the petition, I was just wondering
Eh,
why.
Your Lordship, this is a fit case for CBI, and STF.
That is basic. Why the petitioner went to jail, because petitioner is outside, scared. I don't know, I have just, that is basic.
Yes, because I, as a working as a advocate's clerk in district court since 1 year, so I visited there.
The advocate clerk has no business to go to jail. If something has to be there, then only she will go.
After 1 week, I will visit there. That day, Saturday, after visit of BJP office, I submit a petition, like same petition to CM sir. After that, I visit there. Every week, I have bail regarding bail matters. So I visit there. Everyone have right to visit in PR. But Your Honor, Sunday some girls prostitute are there, and they are very corruption place. All drugs and all are there. But I am not able to visit
Okay,
there.
you filed the additional affidavit.
Yes,
Will say.
Lord.
Heard. Miss Soyoda Mazida
Yes,
Begum,
my lordship.
the
Yes,
petitioner in person,
my lords.
Mr. Nat, learned senior government advocate for the state respondent. Person to order dated 9/8/2026, the executive engineer, electrical executive engineer, PWD Gauhati Electrical Division, personally present before the court and apprise this court that renovation and repairing.
Yes.
Renovation and repairing of the CCTV system is going on, and
The work given means repairing, extension and replacements of servicing.
repairing,
Extension, replacement and servicing.
servicing in the central jail Guwahati is going on, and though the cameras are working, yet the recording could not be done due to absence of license, and the entire process may be completed within a period of 1 month from today.
Expectable, not
Approximately within a period of 1 month from today. And in that view of the matter, this court is inclined to raise the matter after a week. No, sorry, after 4 weeks. And in the meantime,
short date given, Your Lordship, it's
Mr. Nath learned senior
May
government
not be
advocate
short date
may
given.
file his affidavit in opposition. Today we issue notice also. Issue notice to the respondents. However, no formal notice is required to be issued since Mr. Nath entered appearance and received notice.
Lordship, kindly short date given.
Further, considering the nature of allegation made in this writ petition, this court is inclined to direct the district in sessions as Guwahati, Kamrup M. Guwahati, to visit the central jail and to furnish a report in respect to the present status of CCTV system in the central jail, also in respect of the allegation made in the FIR. The report shall be submitted before next date. List the matter on.
Your Lordship, kindly short date given. Lordship, kindly short date given.
No, the district judge will visit the central jail and will prepare a report and file the same before this court.
I have received things, whatever I have said.
4 weeks long.
From the IGP judge. No, that may be.
Mr. Nath, learned senior government advocate, has also produced the instruction which he has received from the Inspector General of Prison, Khanapara. The same shall be tagged with the record.
Public.
Item 52.
The appearance may be dispensed with.
Yes, appearance of the executive engineer is not dispensed with.
Charge sheeted case, Lordship. I'm in custody for more than 1 year, 25 days, Lordship. Out of Lordship, 70 witnesses, still that 6 have been examined, Lordship. I'm in long incarceration, Lordship. Lordship, can
So the case is under section?
It is 103, murder, Lordship. Allegation is murder, Lordship. Lordship, also in a page, Lordship 52 is a type copy of the 47 notice. There is no grounds of arrest, Lordship. Page 47, sorry, page 52. I'm not on the merit, Lordship. The type copy, Lordship. No, nowhere written the grounds of arrest, Lordship. Regarding Lordship 48 notice,
No, in page number 57, grounds of arrest is there.
52, Lordship.
54.
Type copy, Lordship. Detailed grounds of arrest into this, no? May I read the grounds of. Here is written, Lordship, he is FINM accused person. The incriminating materials found against the accused person. He is admitted his guilt and his involvement in the crime. He is arrested for recovery the crime weapon and discover the other facts related with this crime. He has committed offense which is non-bailable. The accused person is arrested to prevent him from making any inducement, threat, or promise to the family members of the victim or witnesses. The accused person is arrested to ensure his presence in the honorable court. That cannot be grounds, Lordship. Maybe reasons, Lordship. Lordship, it is very much specific. 47 47. Lordship, 47(1), Lordship. Lordship, every police officer or other person arresting any person without warrant shall forthwith communicate to him full particulars of the offense for which he is arrested or other grounds of for such arrest, Lordship. Full particulars of grounds of arrest, Lordship. Here also in Prohibitions is there also, Bihan Kumar is also there, Lordship.
Yes, Mr. Bartakur.
48 notice is not provided, bro.
First of all, in the 47 notice for the detailed ground for he is expected to make it all the details are there. Now that regarding that aspect, regarding that grounds are not sufficient. In this case, the detail for the we find the respondent is not eligible for both on credit and credit form discussed by both the there is a attempted to one funding of council and one funding of editing between stakeholders. While the first category might receive the where there is a potential for in the second category, here one has to see the prejudice cost to the accused. In the facts of the incident case, it is not really the respondent was not found with the ground for arrest. Hence, the case of the respondent was the second category discussable. The respondent has also not taken the same plea at the earliest point of time, having done so only in her possibility. Very good. So the earlier
regarding my 47 notice,
his own stand the eyewitness.
I am not on the merit.
Now he is submitted on that point. Therefore, it is not that 47, but notice was not signed. The notice was the 47 notice start. Along with till down now he has submitted that those grounds are not.
Lordship, it is a case of murder.
One by one.
Sorry, sorry.
Those not sufficient that this judgment of the Supreme Court is very clear, madam. That is not a case that might have proven non-compliance of section 47. Otherwise, although in this case, well, from my point of view, all those grounds were there, that
court at any point of time, my lord, he is not entitled for defense.
Lordship 47, sir, Lordship, it is a murder case. It is not a single word is written here in it's a. আপোনাৰ হ'ল যদি মই ক'ব পাৰোঁ। I'm not on the merit, Lordship. Lordship, in my point of view, Lordship, 47, in 47 notice, there is no grounds of arrest. 48 is not provided to me, Lordship, to any members or any friends. 48 is a 48 is not provided. Can you see I have marked this order dated 1905, that of production. The trial court order also reflect about the notice of 47. Regarding 48, it is silent, Lordship. 48 is not provided, Lordship. Now, Lordship, another point, Lordship. Yes, 55, Lordship, memo of arrest. The type copy, Lordship. Lordship, here also no grounds of arrest was mentioned, Lordship. And as per DK Bosu, Lordship, memo of arrest must be attested by one of the witness. It is lacking here. No witnesses' signature is there, Lordship. In DK Bosu, Lordship, paragraph 35. Paragraph 35. No, DK Bosu 35, Lordship, 36 regarding 36B BNSS. Earlier it was 41B CRPC. Lordship, paragraph 35. Paragraph 35.
So, if it is not complied with, then what would be the consequence?
Lordship, it was not attested by witnesses, the arrest memo.
No, that's all right. What would be the consequence for non-compliance?
It is violation of Article 22(1), Lordship, fundamental rights. Lordship, this is decided in the DK Bosu, this is paragraph 35. May I read, Lordship? We therefore consider it appropriate to issue the following requirement.
No, in which part it is observed that it is violation of 21?
Lordship, it is written here, may I read, Lordship?
Regarding that, to point out one thing, madam, because regarding that, because there is conflicting reason of High Court and for which tomorrow, madam, that matter was flipped with judgment with the department. Today is fixed for education development. 36 years. Tomorrow, madam,
Tomorrow.
That's my first count is a long incarceration. I am 1 year, 25 days in custody. Out of 17, only on.
No, you see, the offense is serious. Offense is serious. On merit, you may not be entitled to bail.
I am not made on the. I am not made on the case, Lordship. The 48 notice is not provided, Lordship. Apni admit kore sake. The 48 not provided, Lordship. It is reflected in the order dated 19/7/2025, Lordship. In regard
Okay,
to
then we'll consider it day after tomorrow. Let the judgment be delivered tomorrow in the division bench matter.
regarding 47, no grounds, Lordship. There is no grounds of arrest, Lordship. 47.
We'll see.
Yeah, Lordship.
Or Mr. Soria, learned counsel for the petitioner. For the accused, Mr. Portago, learned additional petition for the state respondent. List the matter on Thursday for further consideration as part heard.
Develop.
28.
Maybe here, FIR is at phase 16. If it is, if it made a queries regarding maintainability of anticipatory bail application in if it has
And DPS matter.
yes.
Yes.
That the very issue is has been raised on the very first day, Lordship. On the day when if the FIR demonstrates prima facie materials, then it is not maintainable. And So what is there in the FIR? Ah, I promise it. That's it. 2, 3 judgments are there.
Hmm.
And the FIR for prima facie case, it has to fulfill the conditions that, that is lordship. Just make it out.
6.1, the absolute nature of one, however, would be it and has to be applied with care either. In a given case, where on the basis of it, the offense under section 3 of the Act is found to have not been made out, that the requisitions related to the commission of such offense are devoid of prima facie merit, the court has to make room as they want to exercise the discretion to public to understand. Not making a prima facie case about the commission of offense is fast to be such a situation. Whereas the court can arrive at such a conclusion in the first said by way of the first impression of the offense in the FIR manner. The contents and the allegation in the FIR will be decisive in this regard. 6.2 manner. Furthermore, in reaching a conclusion as to whether prima facie offense is made out or not, it would not be permissible for the court to travel into the evidentiary or to consider other materials, not the court.
Hmm.
In the FIR, lordship,
Hmm.
in the FIR, is the allegation is that original. First, second, the accused Lavita Gogoi denied her proper care and medication and used, yes, lordship, and used caste-based lawyers knowing that she belonged to missing community. Due to this persistent harassment, mental torture by Plavita Gogoi, my wife was left with no option but to take her own life for bringing
So,
act.
going by the facts mentioned in the FIR, can it be said that no prima facie case is made out against you?
No, not at all. Because
Hmm.
let's say it should be in public or public,
Hmm.
the language is within public view or in place within public view.
Hmm.
And this suicide, lordship, there is a suicide note. Suicide note doesn't in not way indicated anything so far as the ST-SC Act is concerned. Perhaps it is there in the case that so far as ST-SC Act is concerned, it is, let's say, afterthought. Because
Yes.
in the month of April, lordship, 2025, the mother-in-law, the deceased has left the flat from Gauhati, lordship, and she used to stay at Dibrugarh. Suicide has been committed at Dibrugarh, lordship. After leaving the Gauhati house, April, May, in the next month, they had a telephonic conversation. Thereafter, no communication, nothing has been there. It is 7 or 8 months. Lordship. And for becoming abatement, lordship, there should be some proximity. That proximity is also not there. Instigation and proximity, both are absent.
In any place within public view.
Yes. The two term, one is in any place within public view, and S provides cast this by name in any place within public view. Both are. If it may be within the house, even then it can, let's say, if public is available, but nothing is there in the FIR. When I have made, what kind of abuses were used to inflict, nothing is.
So you have forced her to leave the house, out of the house.
No, Lordship, that what they have trying to project is, Lordship, the suicide note is available. Lordship will peruse it. Nothing is there.
No, maybe what is there or not in the suicide note may not be the concern of this court, but their perusal of the
No,
FIR.
what
As per this decision, this court is not supposed to conduct mini trial. Your name is there in the FIR, specific allegations are there.
No, these are not specifically even what abuses has been inflicted upon. Nothing is that. Simply blanket bracket. I'm reading again it.
No, not necessary to read out it again.
The accused, Plavita Gogoi, repeatedly forced my wife out of the house, denied her proper care and medication, and used caste-based slurs, knowing that she belonged to missing community. Due to these persistent harassment and mental torture by Plavita Gogoi, my wife was left no option but to take her own life.
So can it be said that no prima facie case is made out?
No, Lordship. If Lordship construed to be a prima facie, I have nothing to say. But so far as these allegations are, in nowhere can be said that there is a prima facie case. Because
How?
Lordship, so far as public view,
what do you mean by prima facie?
Without, it is apparent, which is apparent.
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 Is it not apparent after perusal of this FIR?
When I have forced it, even when I have forced her out.
You see, use caste-based slur, knowing that she belongs to the missing community.
There is nothing specific. There's
what specific is required? What do you mean by prima facie?
No, prima facie means these are, because one has to fulfill.
No, you first tell me what do you mean by prima facie?
It is apparently without further inquiry or without going to the evidence. And
is it not apparent from perusal of this FIR?
Whether Lordship merely the mere acquisition is not sufficient. That is there. Because
Mere accusation. So is it mere acquisition or there is substance? We have to conduct a mini trial like this, is this? Is it permissible?
তেওঁ বেলেগে গৈ আছে, ইয়াতে গোটেইখিনি লিখিব লাগিব। If there is any whisper regarding that, if that is the prima facie, then I have nothing to say. That's it.
No, you could not say what is prima facie case. You have failed to explain it. What do you mean by prima facie? If you are not ready today, okay, all right. We will list it tomorrow. You come prepared. What do you mean by prima facie? Okay. Heard Mr. Dotto,
Day
learned
after
counsel
tomorrow, Lord. Can it be?
for the applicant.
Day after tomorrow.
Also heard Mr. Bortakur, learned additional paper for the state respondent. List the matter day after tomorrow for further consideration.
Well, he has to fulfill his
And on that day, Mr. Dotto has to satisfy this court what prima facie case means.
Obliged.
For hearing, item 36. Hearing this case, the learned friend has concluded its hearing, the argument, and no issue involved in this particular appeal regarding the fact of objection raised by me. But this particular appeal is not intended to the fact that number one, who has claimed his right as the legal heir, being the adopted son of the concerned land holder. So whether he was in a position to establish that fact and whether issue was accordingly paid, and subsequent to that, something naming of the issues, any order was passed. Learned trial court as well as the law defense court passed an order stating that there is no evidence on record which will substantiate the fact that the plaintiff number one was the adopted son of Jaladhar Roy. So this is the core issue involved in this particular second appeal. Now my learned friend has relied on certain judgments stating that the other plaintiff, the plaintiff number two, who is having substantial interest over the suit land, he can prefer an appeal independently. So basing on that particular submission, he relied on certain judgments, and Lordship has directed me to peruse those judgments and taking note of the observation of this particular judgment, whether I want to add anything for this honorable court. Now, these particular judgments related to the provision of Order 41 Rule 4. My learned friend has referred to the particular provision that when the few plaintiffs or defendants were there, if some one or two plaintiffs or defendants prefer an appeal and some other plaintiff or defendants did not prefer. In that way, there's a procedural part in the court of civil procedure. Then the other plaintiff also, the defendant can also prefer an appeal. Now, the one interesting point which is to be taken into account is that the ground common to all the plaintiffs. Because this is the cardinal principle of the Order 14 Rule 4. The ground should be common to all the plaintiffs. Here in this case, the suit was filed although by two plaintiffs, but the grounds were not common to all the plaintiffs. Because the plaintiff number one in his plea was claiming to be the adopted son of Jaladhar Roy. Whereas the plaintiff number two, he said that I purchased the property from the plaintiff number one. Now, this purchasing of the property by the plaintiff number two would be a legal document if the plaintiff number one would have established the fact that Nirod Roy, the plaintiff number one, being the adopted son of Jaladhar Roy. Now the learned trial court as well as the lower appellate court categorically arrived at a finding that the plaintiff number one had failed to establish fact that he being the adopted son of Jaladhar Roy. So that with regard to that adoption of Jaladhar Roy, the plaintiff number one, this issue is judgment in person. This is not rare. Judgment in rare, because this is not substantially affecting the right of the other plaintiff who is the appellant before this honorable court, the Rampreet Kumar Roy. Now, since the Nirod Roy has not preferred any appeal before this honorable court, the second appeal, so that particular issue with regard to his adoption part
that he is not the adopted son of the Jalandhar Roy, that had patent finality. So in that view of the matter, there is no substantial question of law involved in this case. And this present appellant cannot prefer any appeal because he had purchased or claimed right over the land only on the basis of the fact that he had purchased the property from this Nirod Roy, who being the adopted son, and stepped into the shoes of Jalandhar Roy. So that issue, since it has been adjudicated.
So this present appeal is not preferred by Nirud Roy.
Exactly, Lordship.
It is preferred by plaintiff, plaintiff number 2, Ramkumar Roy. So according to you,
Yes.
Ramkumar Roy purchased the land from Nirud Roy.
Exactly, Lordship.
And since
Okay.
Nirud Roy has no right, title and interest, he cannot sell the property to plaintiff number 2. That is your case.
Because that issue, if he is not the adopted son, so he has no authority to sell the property in the Jose right. Who is he? He has no locus standi. Because that issue has been settled by the lower court as well as by the appellate court. And now, Nirod Roy is
And
not-
Nirud Roy has not challenged the same
Exactly, Lordship.
in
That issue has added finality, Lordship. And whatever the
Appeal.
learned friend has relied on, this is only with regard to the common. Order 41 Rule 4 is this judgment of 1961. Ground common to all plaintiffs or to all defendants. Now here is this ground is not common to all the plaintiffs.
order
Number
for
one is claiming
order
the
41 rule.
Rule 4, Lordship. And another interesting judgment which has been relied by my learned friend is of 1970 with regard to legal representative being the adopted son. So here in this case, the court specifically stated, we may at the very outset mention that Shyam Bahadur Lal had not been able to establish the custom treated by him, nor was he able to adduce any satisfactory evidence about the actual adoption, but he has produced considerable documentary evidence. Here in this case, no documentary evidence, nothing of that sort. This judgment goes against the appellate lordship, this 1970, which has been relied by him. Because we are stating certain facts, it's not the substantial proof. He has to adduce evidence to establish the contention of the treated fact. So my humble submission before this committee is that there is no substantial question of law. It is a question of fact. And since the appellant number 1 is not, the plaintiff number 1 is not before this honorable court, so that issue with regard to the adoption part has been final. So he cannot take the plea of adoption here in this stage. That is the thing. I will not drag this argument any further. On several occasions, the hearing has taken place.
Mr. Ghosh, any reply?
Lordship, my lord, that is the truth. That's the question is this, my lord. Whether, my lord, a appeal preferred by the appellant number 2 here, my lord, is dependent on the facts that they pertains to the appellant number 1, my lord, who has not preferred this appeal, my lord. Because, my lord, the appellant number 2 is derives, my lord, the possessory right from on the strength of the respondent number, plaintiff number 1, my lord. Because he purchased a joke right, my lord. Whether it is not there or not, that's a different issue, my lord. But therefore, my lord, and the relief claim is that, my lord, for declaration of right and possessory right over the suit land, my lord. Now, in this case, my lord, my lord, 2009 SCC 510. Here also, my lord, lordship is very small judgment.
Page number?
My lord, 2009 SCC 510, my lord. Lordship is paragraph 3, very small judgment, my lord. The short question was the High Court in the impugned judgment was justified in taking view that defendant number 2, who was one of the appellant in the second appeal, had now Lucas tendency to maintain the same. It was held that defendant number 2 was the purchaser from respondent number 46, but it is difficult to appreciate as to how it can be said that he had no Lucas tendency to maintain the second appeal, and for demonstrating his vendor had legal right title to convey the property to him. Order 14 Rule 5 of Code of Civil Procedure also apply in such a case. So here, my lord, I am claiming that I have my jot right I have purchased from the plaintiff number 1. Here, plaintiff number 1 has not preferred any appeal, my lord. But my right relates back to, my lord, the plaintiff number 1. So to protect my right, I have filed this appeal, my lord. So therefore, my lord, non-filing of appeal by the plaintiff number one, in my humble submission, cannot ousted me
No, no.
from the purview of.
You have purchased the property from Nirud Roy,
Yes,
the Ali's adopted son of
yes, yes, yes.
Jalandhar Roy.
Yes, my lord. Now, whether adoption is pro bono, that's a different issue, my lord.
No, no.
That is,
The trial court as well as the first appellate court has
Yes.
already decided that Nirud Roy is not the adopted son
yes,
of
yes, yes,
Jalandhar Roy.
yes,
In that view of the matter,
yes.
how you have acquired right to sell the zoot right to plaintiff number 2, the present appellant here.
I'll just focus on that point also, my lord. I'll just focus on that point also. First, I said order 41 rule 4, my lord.
Hmm.
Order 41 rule 4, my lord.
Hmm.
Now, so far, my lord, his right is concerned, my lord. If your lordship look into the, my lord, the evidence of, my lord, it is it has been established that, my lord, maybe that I am the nephew of the plaintiff, my lord, the nephew of the Jalandhar Rai, my lord. Plaintiff number PW1, PW2, they have
No,
said,
no,
my lord, even in the
first,
cross examination.
You have to establish that Nirud Roy has acquired the right to sell the zoot right to
Yes,
you.
Yes, ma'am.
If he is not the
But because
adopted
of
son,
his inheritance, that is why my lord.
if he is not the adopted son,
Because of
then
the
if
inheritance.
he has not acquired any right, how can he sell it to
My
you?
lord, because of the inheritance.
Hmm.
Because Jalandhar Rai is a tenant. My lord, if your lordship looking at a particular Jamabandi exhibit 3. Exhibit 3, Jalandhar Rai's name was there, his wife's name was there.
Hmm.
Their name was mentioned in the suitland.
Hmm.
I am the nephew, my lord. That has been admitted
Hmm.
by PW1 and PW2 in their cross examination also, my lord.
Hmm.
So from that point of view also, my lord,
Hmm.
and both Jalandhar Rai and his wife was issueless, my lord. Then after death of the Jalandhar Rai, property devolved on his wife. And after devolved of the oil, what will happen? Section 15 of the Hindu Succession Act. Lordship may kindly see for the time being. Section 15 of the Hindu Succession Act.
No, on
that
the
will-
other day, you have shown that provision to this court. On the other day, you have
Yes,
argued
yes,
on this
yes, yes.
point.
So in view of that, my lord, secondly, upon the heirs of the husband as per section 15 of the Hindu Succession. So I am the heirs of the husband of the family. That means, my lord, my aunt.
Hmm.
So that point of view, and my lord, line of appellate court has not taken the evidence of that PWD 1 and PWD right perspective. There is no discussion that yes, there is an admitted fact that he is the nephew of the Jalandhar Rai. That fact is not there. That discussion was not there. In my humble submission, subject to my lord's correction, my lord, this is a case, my lord, for exercising of power under order 41 rule 23, my lord. Just I'll place my lord 2 decisions. One is my lord's decision, and another is by Justice N. Chowdhury. Obligement. I have. Well, there is no discussion of this evidence, if your lordship, PW1 and PW2 in the cross examination, there's a cell, I am nephew. Because it is the duty of the, my lord, the first appellate court under order 41 rule 33 CPC.
Yes, Mr. Sodore. If the plaintiff number 1
Yes.
is the brother's son of Jalandhar Roy, whether as submitted by Mr. Ghosh under order 41 rule 4, he can prefer this appeal. The appellant can prefer this appeal.
No, what I am submitting is that particular issue has expired, you can prefer appeal.
There is no bar in the appeal, but that issue with regard to the fact that I am the plaintiff number one is the adopted son, that issue has attained finality, he cannot raise the issue.
No, no, as per section, 15 of the Hindus Succession Act.
No, section 15 of the Hindu Succession Act will come into play here, because in two ways he cannot take the same plea. On the one hand, he is saying that I am the adopted son. If the plaintiff number one is taking the plea of adopted son, that issue has been rejected by the trial court as well as by the lower appeal court. And subsequently, he cannot change the other plea of section 15 of the Hindu Succession Act. Because he is claiming his right as a
No, no,
adopted son.
he can take contradictory plea. There is no bar.
Yes.
He can take contradictory plea.
No, in the plea, that plea was never taken.
That plea was not there.
Never taken. So how he can take the plea here? This is not a substantial question of law. This is not fair. Doing something and taking some plea in the second appeal stage is otherwise not permissible.
My lord,
He-
paragraph 4, Jalandhar had no issue. As his old days, his nephew did not die.
Nephew,
That
yes.
nephew, yes.
He
If
said about
this
the nephew,
playing
but
is
he
there.
claimed he is the adopted son. He was not claiming anything as a nephew. He was claiming the share over the property of being the adopted son.
That he miserably
Failed to establish for the child trial court. And that is the reason why he has not preferred any second appeal before this one. He has accepted the proposition.
Heard Mr. Vijay Ghosh, learned counsel for the appellant, Mr. Chaudhary, learned counsel for the respondent, argument concluded, judgment reserved.
My lord, this plea, I have raised my lord lordship, my lord subject to lordship correction, may also assume jurisdiction under my lord provision to section 100 subsection 5 CPC. My lord.
Subsection 5.
Yes, provision to 5, subsection 5 of section 100 CPC.
What is
Proviso.
stated there?
It said, provided that nothing in this subsection shall be deemed to take or abridge the power of the court to hear for any reason to be recorded the appeal on any other substantial question not formulated by law.
No, Mr. Ghosh, you see, the plea which you have never taken before the trial
Well,
court,
pleading is there.
and also
pleading is
appellate
there,
court,
my
you
lord.
cannot raise in the second
Pleading is
appeal.
there, my lord. In pleading is there that he is the nephew, and my lord, the evidence also stated that he is the nephew.
no, you are,
That is an admitted part.
No. Okay.
Your lordship, kindly pass over this matter for a time being.
We do not have mass matter. So,
Please, accept responsive from the in court number.
okay,
Kindly.
Lordship, can it be on Thursday, Lordship?
Thursday,
Thursday, Lordship.
It's on.
Thursday, a lot of cases have been fixed already.
Yes.
May I please, Lordship? But this case is led by my senior PS Hazarika. He has some difficulties today, my lord. So can it be on any other day, my lord, next week, my lord?
Okay. On the pair being made by Mr. Gogoi,
M. Setia.
M. Setia, learned counsel appearing on behalf of Mr.
T.S.
You
Hazarika.
are the conducting counsel here,
Yes, my lord. So case is led by
learned
Mr.
counsel
T.S.
for
Hazarika.
the petitioner. Submits that conducting counsel, Mr. Hazarika,
Hazarika, my lord.
is,
Has some personal difficulties, my lord.
has some personal difficulties today, and as such, he prayed that matter may be listed after 1 week. The pair having not been opposed by Mr. Learned counsel for the respondent stands allowed. List the matter on 25th August.
Not right.
May I please proceed? Lordship, it is an NDPS case, Lordship, commercial quantity, Lordship. And appellant is behind the bar 3 years, 8 months, Lordship, almost.
Lordship, in earlier time, many dates have been taken and finally today listed it for hearing, Lordship. Lordship, I have seen three things, Lordship, the judgment, Lordship. The judgment I have annexed in my petition, Lordship. Lordship, police fails to fulfill the compliances under section 42 of the NDPS Act, Lordship, number one. And number two, police fails to fulfill the compliance under section 43 of NDPS Act, Lordship. And there is big contradiction, Lordship, between among the statement of the PWs, Lordship. Lordship, let us go through the judgment, Lordship. Thank you. Lordship, in the judgment, Lordship, kindly go to paragraph number 6 and 7, Lordship. That is the statement of the PW1, that is informant, Lordship. Lordship, paragraph number 6, the last part, Lordship. Lordship, the informant saying that is he duly seized all the suspected contrabands in presence of the independent witnesses and seal peg the same and hand over the seized contrabands to the Malkhana Sirostadar in presence of OC of Golokganj PS, Lordship. Lordship, kindly paragraph number 7, Lordship, in cross examination. This informant saying, Lordship, sentence number, second sentence, Lordship. He has not mentioned in his FIR which accused was traveling in which vehicle, Lordship. The informant does not know. Actually, there are three accused person, Lordship. Two was minor and this appellant was major, Lordship. The minor two, they got bail, Lordship, at the time of arrest, Lordship. Lordship.
So how many vehicles are there?
Lordship.
How many vehicles were there?
Two vehicles are there, Lordship. And three accused person, two was minor, Lordship. Although he communicated, next line, Lordship, although he communicated the higher authority regarding the search and seizure of the incident in writing, but the same is not available on the record, Lordship. He is stating that he has communicated, but there is no any record in the in the record file, Lordship. In the FIR as well as his statement recorded under section 161 of CRPC, Lordship, he did not mention that he duly seized all the suspected contrabands. He duly seized all the suspected contrabands in presence of independent witnesses and seal peg the same and hand over the seized contrabands to the Malkhana Sirostadar in presence of OC of Golokganj PS. But he did not examine the Malkhana Sirostadar and OC of the Golokganj PS, Lordship, under section 161 of CRPC, Lordship. And they seized at midnight, Lordship, the contrabands at midnight, Lordship. In the FIR, it is stated, Lordship. He admitted, Lordship, that he has not submitted any certificate regarding the authenticity of the pen drive deposited in the instant case. There is no any written certificate, Lordship. He also did not submit the camera used for recording the videography in the instant case, Lordship. He further admitted, Lordship, that the authorization letter does not contain the time and issue number, issue number of its issuance, that he received the authorization letter on the next day of the incident, Lordship. Lordship, without getting the authorization letter, how he can see the articles, see the contraband, it is the violation of section 42 of NDPS, Lordship. They have written the FIR on dated Lordship and see the article on dated 19/1/2023. But seizure list they have made on Lordship 21/2023. That's why it is written here, he received the authorization letter on the next day of the incident, Lordship. In the authorization letter, that is A1, was shown as pedestrian, not as driver, Lordship. The appellant is shown as pedestrian, not as driver, Lordship. He further admitted that he did not mention the name of the police persons who accompanied me in the Naka checking, Lordship. Lordship, kindly see next paragraph, Lordship, that is independent witnesses, independent witness, Lordship. Last line, Lordship. I am reading only last line. The police took his signature in a piece of paper as witness. Police told him that he is made a witness for the recovery of the said ganja. But police did not explain what is the contents of this piece of paper. In cross examination, it is said, Lordship, in the next sentence, Lordship, PW2
Who is
has
the statement of who is witness you were reading?
it is
Independent
one
witness, PW?
one independent, that is Mokbul Haq, PW2,
PW2. Yes.
Mokbul Haq, Lordship.
Mm.
In cross examination, Lordship, he has admitted that he does not remember the registration number of the vehicle, Lordship. And he did not read the content of the seizure list, which was not read over to him, Lordship. The seizure list was not read over on him, Lordship. He does not know how much contraband was recovered from the two vehicles, Lordship. Police only asked him to put his signature and no further question was asked by the police, Lordship, to this independent witness, Lordship. Lordship, now let us go to PW number 3, Lordship. It is also an one independent witness, Lordship. That is Ahadul Ali Mullah, Lordship. Lordship, it is written, Lordship, in the third line, Lordship. Police requested, para number 10, Lordship. Police requested him to put thumb impression in a piece of paper. He does not know the contraband of the seizure list, Lordship. His cross-examination was declined, Lordship. Lordship.
So total how many witnesses examined here?
Lordship,
Seven.
Lordship.
Out of seven, how many independent witnesses are there?
Three, PW 2, 3, and 4.
Yes, 2, 3, yes, independent 3, Lordship. And Lord, there is no any defense witness, Lordship. In
PW 2, 3, and
4.
4.
There is no any defense witness. No DW, because at the cross time, during the trial time, he was behind the bar, Lordship, and he is from Tripura. Lordship, the third independent witness similarly said, Lordship, only two line, Lordship.
No, even then, if the independent witnesses have not implicated him with the search,
yes,
then if the police personnel implicated him with the search, can we discard the evidence of police officials?
Yes, sir. Police officers, witnesses are also, there is discrimination, Lordship. I am going to that point, Lordship.
Discrimination?
Yes, witness the statement given the police officer, the Sirasta, the informant, the IO. There is so many discrimination, Lordship. and they did not follow the procedure of section 42 and 43, Lordship. Lordship, police personnel, that is the IO, Lordship. Kindly see the statement of IO, Lordship. That is PW6, Lordship. That is PW paragraph number 16. Section 42, Lordship. Clause 1 and 2, kindly, Lordship.
Who is the informant who apprehended the vehicles?
One police officer, Lordship.
PW1. What is his rank? SI or inspector?
Yes, I. Can you see the FIR? Sure.
So, in your case,
SI, Lordship.
in your case, which section will be applicable, 42 or 43?
42 and 43, both are not compliance, Lordship. By the
No. Which
42
will
and
be
43,
applicable,
both,
42 or 43?
both are applicable.
Both.
Lordship. Seizure, seize and seizure, search, seize, arrest, and
So
Lordship.
you have been apprehended at a public place on a road?
Not public place, arrested not in public place, inside the police campus, Lordship, at the midnight.
Where you have been apprehended?
In the police campus, Lordship.
Why you have gone there?
Because it was, I think, Lordship, 8:30 p.m., Lordship.
Why you have gone there?
Lordship, actually, I am a driver, Lordship, professionally driver. Two partners, Lordship, Yusufdev Burma and Dharmandev Burma, Lordship.
Where
From
is the
Tripura,
FIR?
Lordship. They called me along with the other, Lordship. They called me along with the other accused person and informed me that they have sold two vehicles, Lordship, to Boksirhat, West Bengal, Lordship. And I have to take the vehicle by driving, Lordship, to Boksirhat. In return, Lordship, I have been given, they have given, Lordship, 5,000 per vehicle, Lordship. That's why I went there, Lordship. That is Centro vehicle.
When you have been arrested?
Lordship?
When you have been arrested?
Lordship, when I reached that Golokganj, Lordship, when going to Boksirhat, Lordship, in Golokganj, there is a Naka checking, Lordship, near the marketplace, Lordship. But seizure, and I have been arrested inside the police station, Lordship. At the midnight time, and Malkhana not checking, there is no signature, pagination.
Mr. Counsel,
Lordship.
your submission is wrong. You have been apprehended on the road.
Lordship?
You have been apprehended on the road.
Apprehended, yes, apprehended on the road, but arrested and seized the article
Maybe.
inside the police station, Lordship.
So if you have been apprehended at a public place, which section will be applicable, 42 or 43?
43, Lordship.
43.
43.
43. Then why you are submitting that 42 is violated here?
42, because 42 it is saying, Lordship, search and seizure must be between sunrise and sunset. There is exception, but exception must be recorded in writing, Lordship. But the police did not record the grounds, Lordship, in the FIR. Why he has search and seizure at the midnight time, Lordship?
No, during Naka checking, you have been apprehended.
Yes, Lordship.
And at that time, you tried to fled away.
Arson seizure should be, Lordship,
Hmm?
that is between the sunset and sunrise. Now, that is 42 saying, Lordship. And 42, Lordship, subclause 2, it is saying that only the authorized officer can search and seizure such offense, Lordship.
Hmm.
But the police recovered the authorization letter next day, Lordship, not the same day, which is illegal, Lordship. Lordship, in this regard, Lordship, I would like to submit to judgment, Lordship. It is clearly saying here.
On who is that you have been apprehended?
Lordship,
On who is that you have been apprehended?
21, 2023, Lordship.
21.
Yes, Lordship.
So
Actually,
the
19-1,
authority,
Lordship, actually
authority
19-1.
letter is,
There is
authority letter is dated 19/1/2020.
Yes, that is contradiction, Lordship. It is in cross-examination, it is saying that it is 19-1. But they have recorded it, that is 21.
Where?
Why that is, it is, I am already said that without getting the authorization letter, they arrested and seized.
No, they have exhibited the authority letter as exhibit P3.
Yes, but Lordship, in cross-examination of PW6, kindly see. Cross-examination of PW, it is saying that actually it is on 19, they seize, but authorization letter got on 20, Lordship.
No, who will prove the authorization letter? Who had given the authority or to whom the authority was issued?
The superior of the police officer.
Hmm.
Lordship, I have given a judgment, first I have given a judgment. Lordship, kindly see only one page, Lordship, page number, that is Supreme Court judgment, State of Punjab versus Balbir Singh, Lordship.
It is there, but here when the authority letter is proved and it was issued on 19/1/2023, can it be said that the provision is violated?
Lordship, that is in, let me see. Yes, Lordship. In paragraph number 20, Lordship, of the judgment.
Who is witness stated?
That is CW Sirostadar.
No, Sirostadar has nothing to do with the authorization letter.
Not authorization letter. He is telling about this, Lordship.
Which one?
CW1 has stated that the relevant entry was made on 21/2023.
Relevant entry in respect of?
21 relevant entry was the seizure article and the contrabands has been entry in the Malkhana, Lordship, and Sirostadar is the in charge of this Malkhana, Lordship. And he is stating here that the relevant entry.
No, you were submitting about the authority letter.
Yes, it is here, Lordship. It is here. There is no pagination in the Malkhana register. There is no signature of Sirostadar of Malkhana in charge, Lordship, as well as the OC of Golokganj, Lordship. Golokganj PS in the register, Lordship. Lordship, it is clear from this statement, Lordship, that the police did not follow the procedure, Lordship. The authorization letter I have already read. Lordship, in paragraph number 7, I have read, Lordship,
Paragraph number 7 of
the judgment, Lordship. Last paragraph, Lordship. He further admitted that the authorization letter does not contain the time and issue number, and he received the authorization letter on the next day, Lordship. Paragraph number 7, last paragraph, Lordship.
Now, the question is, when you have been apprehended during Naka checking,
Yes, Lord.
whether such authorization is necessary?
For Naka checking,
Yes, Norma?
authorization is not necessary, Lordship.
Fundamental position of deputy one minor
Mm.
is clear that inform the side of it.
Pardon?
From the position of the PW one minor. Inform the higher authority regarding that matter. Incident.
But it is not
Director?
available in the record.
42 subsection 2 minor. That is compliant.
Lordship, but it is not available in the record, Lordship. He admitted in his cross-examination.
So you find it out which provision will be applicable, 42 or 43, and whether in case of a running vehicle, this authorization is necessary or not.
Authorization is necessary. That's why, Lordship, kindly, would you please go to the judgment, Lordship? That is State of Punjab versus Balbir Singh, Lordship. Page number 15, Lordship, only. There is 3-4 lines only.
No, it is necessary, but in case of a running vehicle,
Yes, Lord.
whether this provision will be applicable.
Lordship, it is in second paragraph, Lordship. It is saying, Lordship, second paragraph, only the empowered officer can give the authorization to his subordinate officer to carry out the arrest of a person or search as mentioned therein, Lordship. If there is a, Lordship, contravention that would affect the prosecution case and vitiate the conviction, Lordship. Next paragraph, Lordship, only 2-3 lines, Lordship. Next paragraph. Section 42, clause 1, Lordship. The empowered officer, if has a prior information given
No,
by
whether in case of Naka checking, there was a prior information. In your case?
prior information, yes, Lordship.
Prior
information.
information.
Yes, in the FIR it is written.
Hmm.
That should necessarily be taken down in writing. It is.
Yes, Sarma, have you gone through the judgment?
Lordship, in the,
We conclude today, my lord, I have some another day, my lord, I will.
Hmm?
If,
You have?
some information for me, my lord, I will submit another day.
Lordship, many dates has been gone, Lordship. And now it is,
Complete kara.
yes, okay. Now it is 3 years. I have to complete my argument, Lordship. Lordship, in the same paragraph, Lordship, that I am reading, Lordship,
Hmm?
in the last line, Lordship, kindly see.
In which part of the FIR it is stated that prior information was with the police?
It is not written here.
Not written here. From where you were submitting then?
Sorry, Lordship.
Hmm? If prior information is not there, then whether compliance is necessary? You come prepared. We'll list it on next Tuesday. Heard, Mr. Your name, please?
MM Rahman, Lordship.
Learned counsel for the appellant, Mr. B. Sharma, learned additional PP for the state respondent. Heard in part, list the matter on next Tuesday
Okay, Lordship.
at 2 p.m.
On 18th, my lord.
Correct.
Lordship, my part has been finished.
No.
Oh, okay, Lordship.
Further hearing.
Yes, Lordship. Part.
May I please your lordship? I
Yes.
am hearing on behalf of Mr. K.R. Patgiri. He is on leave in court number 4. Another hearing matter is going on. So neither may fix any date in the next week.
Okay. On the appeal being made by Miss
P. Talukdar,
Learned counsel appearing on behalf of Mr.
K.R. Patgiri.
Learned conducting counsel for the appellant, no, petitioner, raises the list the matter on next Tuesday. Tuesday.
37.
So still in legs. Okay. As agreed by learned advocate for both the parties, raises the list the matter on. Okay.
It
27.
remains as part heard, lordship.
Okay,
It may become on Thursday, lordship.
next week not possible.
It remains as part heard.
Mm.